Thanks, John. Morning, everybody. I'm Bill Nelson. I've been at Godfrey and Kahn for a year, so I've only been in private practice for about a year. And before that, for about 4 years, I worked for the Wisconsin Department of Natural Resources as an attorney assigned remediation and redevelopment program, as well as other environmental management programs. So I'm going to have a somewhat expertise on some of these grant programs that we'll speak to today concerning water quality initiatives that tribes are eligible for that could be part of a development plan or a part of a different project. So there's some quirks here that we can speak to and give you more details. And this is generally going to be an overview of those topics. Then if you have follow-up questions, feel free to reach out to John, Mark, or myself. John, you want to advance the next slide? So,
sure.
Our mugs on there. But
that's right. Yeah. I'll go to the slide. Yeah, there we go.
There you go. So, I'm an associate here. I helped out John on certain tribal matters, and that's been really fascinating to me. But I also do a lot of permit compliance work and environmental, kind of broader work for other shareholders with the firm. And but what I really enjoy are projects like this, where you sort of start from nothing, where it's just an idea and you build it, find opportunities for funding, and then see it turned into something. And I was a former regulator, so I disliked being on the end of the line where I was sort of saying, no, go back, try again. No, like not good enough, try again. Much more satisfying actually helping people with projects to get to the finish line and see what you've built together. So that's a little bit about me. Mark, do you want to give an intro and introduce yourself?
Yeah, thanks. My name is Mark Bender. I'm joined Godfrey and Kahn a couple months ago. I'm the new guy here in town, and I work with John on the energy side, our energy practice, as well as developing projects for tribes around the country. And then I also work in our regulatory practice group, which is kind of anything involving the state agencies here in Wisconsin, getting used to the state regulatory environment. As John mentioned, before coming to Godfrey, I worked at the Public Service Commission of Wisconsin, which regulates all the utilities in the state, as well as administering our energy efficiency program, which has incentives and grants, and then the Broadband grant program, which the state of Wisconsin does an annual grant program. But now, as we'll talk about later in some of these slides, we'll have quite a bit of money, as will many other states, for broadband expansion grants going forward. So that's a little bit about what I do and where I'm from.
Well, with that, why don't we, I think we covered everybody that at least is able to speak right now. So why don't we get started, I guess, and we'll, I'll be turning over to Mark for the first discussion, which is we're gonna talk about organizing for development. And in that, area, Mark's going to talk about forming a development team and partners. And what's kind of important here is this. I think a lot of you have already been through this, but it sounds like there's also a fair amount of folks that are newer to housing, so, and perhaps newer to the development area within housing. So what we did was we just laid out things that we have seen from our housing authority and some related tribal clients that have been important parts of their team, and how they've been able to kind of work together to have a good team to make sure they're pursuing the right projects, the projects that help the tribal housing authority, help the tribe, and help the members, and also have the right members in there. So with that, I'll turn it over to Mark to kind of walk through this set of slides, essentially in this area.
Great, thanks. Okay. All right. So let's say you've just been appointed to the Board of Commissioners of your tribally designated housing entity, or TDHE, or maybe you've just been named executive director or another senior staff position. One of the first things that you probably learn is that the funding you receive under the Indian Housing Block Grant Program, or IHBG, provides enough money to meet payroll and maintain current homes, but not much more. The need component of your IHBG formula grant might provide enough to build 2 or 3 homes, but your community may need 20, 50, or even 100. Maybe you've heard of non-IHBG funding sources like ICDBG, USDA, RUS, FHLB, IHS, or LIHTCs. So how do you get at those funding sources, and what do those acronyms even mean? The answer is that you need to form a organized for development. You need to form a development team to develop expertise in planning projects, learn about the funding sources, and prepare high quality competitive applications. So how do you do that? Who's on the development team? First, you need a team leader. Team leader supervises everybody else and has ultimate responsibility for assuring compliance with requirements that apply to the different financing sources. Team leader has the authority to negotiate with contractors and government agencies, and a major development project cannot succeed without buy-in from the TDHE board and the tribe's elected leaders. Team leader must understand the project, believe in the project, and be able to sell it to the board and the tribe's elected leaders, and make sure that they're kept up to date as the project proceeds, so that when problems arise, and they always do, everybody works to find a solution, no one runs for cover. The obvious candidate for development team leader is the executive director of the TDHE. The executive director, by virtue of the job description, already has executive authority to act as the face of the project to the elected leaders and to outside development partners. If the ED, because of other responsibilities, is unable to serve as development team leader, ED should name some other member of senior management, perhaps a deputy director, CFO, or grant writer. Whoever it is must be trustworthy and report regularly to the ED. In addition, the development team needs a finance officer. Grant and loan applications require financial disclosures, budgets, capital budgets, operating budgets, and pro formas. If your project is projected to have $200,000 per year in operating costs and your projected revenues are $150,000, you need to be able to figure out where that supplemental project funding is going to come from in order to keep the housing project operational. Your finance officer also tracks the uses of project funds, prepares financial reports, certifications to government agencies who have provided the funding, and of course, verifies that the project dollars are going where they're supposed to go, and the tribe TDHE's own books are in order. Project development team also requires an attorney. The attorney advises on the legal requirements of the program's funding for projects. You're probably already familiar with the rules that apply to the IHBG program. If, however, you're getting significant funding under the Housing Tax Credit Program or the Indian Community Development Block Grant Program or the Federal Home Loan Bank Affordable Housing Program, those all come with their own set of eligibility requirements and compliance requirements. In addition to advising on program-specific legal requirements, your development attorney reviews and negotiates agreements with contractors, lenders, and government agencies. Often in connection with the development of projects in Indian country, jurisdictional issues arise. Outside parties aren't familiar with the unique legal environment that applies to Indian country development. They often just assume that state laws apply. So you need a tribal attorney to work through jurisdictional issues with the funding sources and the lenders and contractors and government agencies. You need an attorney to help with any federal approvals that might be necessary, including rights of ways and leases, for example, which normally require BIA approval. Sometimes there's a gap in the tribe's legal code. A development attorney can often be helpful in drafting codes and ordinances that'll help maximize eligibility for outside funding. Fourth key member of the development team is your grant writer. It's not realistic for an ED or deputy ED to master all the programs you need to finance your housing needs and become skilled at preparing detailed competitive applications. Those tasks should be assigned to a dedicated grant writer. Mastering all the funding sources is virtually impossible because there are often too many of them. There's a smaller group of funding sources that are high priority because of the number of dollars that they regularly deliver to Indian country for housing. These include the Indian Community Development Block Grant Program, the IHBG competitive programs, the Housing Tax Credit Program authorized under federal law but administered through the state housing finance agencies, the Federal Home Loan Bank AHP program, and the USDA Rural Utilities and Community Facilities programs. A grant writer who becomes familiar with these programs, including the application cycles, can dramatically increase the TDHE's ability to meet community development needs. Grant writing expertise is available from outside consultants, and for highly complex applications such as housing tax credits, it may be worth the expense. The TDHE develops the expertise in-house, however, is in much stronger position because the in-house grant writer with greater access to tribal information, tribal personnel, and with greater familiarity with the tribal community, naturally develops the ability to adapt earlier successful applications for subsequent applications. So now you've got your development team. All you need now is a development plan, which is our next section.
Thanks, Mark. Let me request control here. I have control. All right. Well, thanks, everybody. Good morning. This is an exciting section, but I did want to, before getting into it, plug the Indian Housing Development Handbook that First Pick has shared in the chat. If you don't have it, I don't like printing documents very often, but this is one that I highly recommend printing and then creating tabs, and should be creased, because a lot of what we're covering today is discussed in greater detail in this handbook, and it really should be called a playbook, because it really tells you what to do and how best practices are found in here. So, and for example, this section is covered on page 5. So you could follow along on today's sections or look in the table of contents. And that, I think that also helps with memory retention if you have a physical thing that you're also following along to when you're consuming pretty complex ideas today. So I just wanted to share that as something that I think would help retain info that you hear today, and also serve as a guide so you can look back. And if you have questions, always you can reach out to me, myself, Mark, or John. So with that, Mark provided a bit on forming a team. So you have your team assembled. Now, what are they actually doing? What are they getting their hands dirty with? And before getting into what a development plan is and how to implement it, you sort of have to clarify what it's for, so define the purpose. And there's really 2 purposes of a development plan. Each are designed to maximize your chance of success. So anything you're getting into or trying to achieve grant money, you want to ensure that this is going to be received as a good bet, and everyone reviewing your applications is nodding along to the concepts that are discussed. As why wouldn't we do this? Why wouldn't we support this project? And trying to clarify that here, things to look for to increase your success of an accepted application and a successful project. So I said there are 2 purposes for a development plan. First, it provides a roadmap for development for all your efforts. Your development plan may change over time. It should adjust over time. And you always need to have an opportunity or a plan for when opportunities arise, because you can take advantage of them and you don't have to start from square one. There may be eligibility for new opportunity from different programs that maybe you may become aware of, or the window may open during your development plan. So you need to be nimble and agile to pivot where those opportunities arise. And then the second purpose of the plan is to support these applications for grants and loans you need to finance the project. So, without funding source, whether it's state, federal, private, no funding source is going to provide you with loans or grant dollars unless you can demonstrate that the project is the product of careful planning and a process that meets the needs of your community and has the support of all the stakeholders. So we're going to talk about that in this section, how to best do that. So what's in a development plan? A good development plan provides essential information about the community. It identifies the areas of infrastructure needs, and some examples of that are on the slide here. Water, sewer, roads, sidewalks, public facilities, housing, energy. All these should be sort of discussed. And if you're having a comprehensive plan, how would this project affect those related infrastructure? And a plan identifies potential projects to meet these needs and prioritize them. And we'll get into all the types of projects today. The 3 that we'll focus on are infrastructure projects, housing projects, and energy projects. And we'll have dedicated sections on each where we'll provide some additional insight. So there's some key inputs for a development plan. Preparing for a development plan requires establishing a baseline of accurate information regarding the demographics of the community that you're aiming to serve. So elements like age, family status, income, members' housing preferences, all those are essential for baseline information for putting a plan together. And one tribal community may have a need for family housing, another may have a shortage of housing for larger families, and yet another may want to put elder housing at the top of the list. So you want to figure out what the priorities are, and you do that through sort of a baseline exercise, figure that out. So you need that good information regarding existing infrastructure within your community also. And you need to be aware of any potential development limitations you have. For example, if there's a shortage of building sites, if so, you need to acquire land before developing. We heard some examples of that in the intros today. Becoming aware of those limitations will drive the need for what the plan needs to entail. You need to acquire property as a part of this. And the plan should include input from the community on the tribe's greatest needs. So this can be obtained through a number of methods. We've seen success through focus groups, interviews with elders, internet surveys, and mailed questionnaires. You just really need to give the input from the community you're serving to ensure that what you are seeking to do will be well received, is popular, and is something everyone wants. And it goes without saying that the development plan must include the view of elected officials, because as Mark pointed out, that their support will be crucial for successful development. So the baseline and fact gathering phase will determine whether you may qualify for certain programs. So many affordable housing grant programs are limited to families whose income does not exceed 80% of the area median income, or AMI, or for the housing tax credit program and a few others, even a lower percentage of AMI. So that baseline really opens the door whether you can reach those certain grants and those certain programs as a threshold issue that can be figured out ahead of time. And a professional market analysis can be very valuable in assuring a third-party funding source that if you build your project, there will actually be eligible families meeting the income requirements there, available and ready to occupy those newly developed units. So it helps paint the picture that, yes, this will be used, this will be successful, and you'll have the right people to be able to live in the project that's being developed. So you've done it, right? You've created the perfect plan. You're done, right? Mission accomplished? No, it's time to now implement it. You have to finance and build this project. And this usually involves balancing the desire to address all of the projects at the top of your list with the reality of what's available to you. So, and that, again, that's in terms of what land is available, existing infrastructure limitations, and potential financing issues. There may be developments in project funding out of your control that might dictate the prioritization of your projects. For example, you may have a project number 3 on your priority list rather than going forward with project number 1, simply because there's a big new grant that's available and the scoring criteria perfectly fit with project number 3. So it may not fit well with project number 1. It makes sense to go with project number 3. So, but being able to explain that and be able to be nimble enough to pivot to where the available funding is and where the best matches are is critical. So, and this contemplates a development plan that has multiple projects that you want to take on. And all of these are ranging from need to would be nice to have in a priority list. And ideally, you want to be ready to go on a handful of projects and being able to choose from among them based on how the stars and timing, things that are out of your control, how those line up. So again, furthering implementing the plan, it's all about maximizing your chances of success. You're training the development team that Mark told about is critical. So once you've selected a project and aligned on a funding source, it's important to train the development team on the regulatory requirements and deadlines associated with the program. A lot of this is deadline-driven work, and it's important to have good grant writers on your team if you can. That's a skill set that's in demand. You need to recognize that most grants are highly competitive, and you might become deeply knowledgeable in each program. You might first have to become deeply knowledgeable to file a successful application. And hopefully we can help with some of that and give you the resources today and references to improve your chances. But you want to present a united front about the proposal. The approval of the TDHE board and often the approval of the tribal government is essential for showing this united front. We recommend preparing detailed resolutions that describe the project's purposes, its costs as you understand them, and all the financing sources, so that 5 years later, it's easier to go back and confirm exactly what was approved and that you had the authority to move forward with this and all stakeholder buy-in at the beginning. And then preparation of grant applications can be very time consuming. It's not an easy process. So unless you have a very experienced in-house grant writer, an outside consulting firm should be considered for communities with many projects that have very complex applications. So consider that as an alternative rather than in-house training if that's the right fit for you. So after your application has been approved, there's still many program requirements to be met. And at that point, you've already trained your staff on the particular financing source, so it should be smooth sailing. But if you have not, you just need to be mindful of getting a yes is not the end. You still have to manage this as a project, and there will be bumps along the road. And the goal is to sort of see those beforehand and anticipate them and being able to plan accordingly. Be mindful that each funding source has its own monitoring requirements, and the key is to meet all the deadlines and provide timely responses to requests for additional information. So that is the main thing. This is not once you get approved, there will be additional information requests to come that will be fleshed out for each of these programs with grants. And many grants can be revoked if these certain benchmarks aren't met. So, or if the funding source doesn't receive prompt responses to its reasonable inquiries about how the money will be used. So it's really an active job managing those sort of requests for information and responses. Continuing the implementation here, the period from grant award to construction completion is always very challenging for especially understaffed designated housing entities. You know, that's just the reality. It's hard to do. There's not enough people to share the burden of this. It's a challenge. So in addition to keeping the funding source satisfied, the development team must address problems that inevitably arise on a daily basis. You know, contracts must be negotiated, usually requires special care with respect to warranties, procurement terms, dispute resolution, jurisdiction, and other issues. We'll talk about best practices on some of those contractual terms soon. You know, you are usually dealing with outside parties that are very unfamiliar with tribal law and unfamiliar with the jurisdictional rules that apply in Indian country. That's just a reality. You'll have lots of third parties that you have to provide some level of education to them for them to understand where you're coming from and what you're asking. You know, this is a task that often falls on the development team's attorney to assist with that. So having an experienced attorney that has done this before with similar projects and can give examples of how it worked well is helpful for any funding source, because they need help along the way too. Compliance with the federal government's Title II, Part 200 regulations relating to procurement and Indian preference in hiring and subcontracting is a really important issue that you'd want to be mindful of and include as part of your plan and contemplate that. And you know, obviously, once you have one project and you've implemented it, you're looking at being mindful of having other priority projects fall in line. And practice makes perfect. You know, when the project is completed, any of the required compliance reports are provided to the funding sources. The next step is to prepare for the next project. So ideally, you're continually reloading these sorts of projects with your team, and you have them in a hopper so where you can dedicate resources as these sort of end. They're not left standing around waiting for the next one, you have another one lined up. So, and balancing that with your team is difficult. So you always want to have multiple irons in the fire, because these projects have wildly different completion timelines. And a successful project lays the groundwork for more successful projects. So while a development always involves stress, it gets easier with experience. That's a main takeaway. So thank you very much. I'll turn it over to John, who's going to provide an overview of applicable federal Indian law and tribal law related to these types of projects and developments. Thank you.
Great. Thank you. Thanks, Bill. And let me move forward onto that. So, so we obviously talked about a little bit about, developing your development team, and then how to think about developments and going forward. I think it's helpful to have that kind of background, so you have the right group together, and then you also have the right plan of action. But another important issue to development is just making sure you're at least generally knowledgeable about the legal background related to development, especially the development in Indian country, because it's a little bit different, as you probably are aware, than outside of Indian country. So we want to first talk through some of the relevant Indian law and tribal law issues related to project developments. What I'll talk about now are three areas, basically: the jurisdictional authority of the tribe compared to the states, sovereign immunity, and then federal approvals needed for projects, especially if you don't have certain tribal legal infrastructure set up first. So the first area I want to talk about is the tribe's regulatory authority over non-Indians in Indian country. And it's interesting because this is an area, and perhaps a little bit frustrating too, because in the past, based on Supreme Court law dating back to 1832, there was a real clear sense that Indian country and Indian tribes and reservations are distinct, independent political communities that where the tribal government basically exercised basically the self-government over that area, and it was pretty clear. That was dating back to a time when there's probably less interaction though between at least in general between Indian country and the areas that are outside Indian country, because they were oftentimes remote compared to other areas of development. But as time has gone by, we've kind of switched over from a situation where essentially state law had no force in Indian country. So it'd be the tribes that were almost like separate subsidiary nations of the United States. They were able to have quite a bit of self-control. Now, it's still a situation where the primary jurisdiction for the area, is with the federal government, as the federal government is, if you're aware, if you've worked at your housing authority, other tribal operations, for a fairly good amount of time, the federal government clearly has authority over, you deal with HUD, deal with EPA, deal with BIA, deal with all these federal agencies that have, regulatory authority from the federal side. And then it also is an area where Indian tribes, the Indian tribe and the tribal government that has jurisdiction of the reservation has essentially primary jurisdiction subject to the feds, and that the states are lesser. But when you start to get into situations where there's interaction between non-Indians and Indians, or non-Indians and non-Indians, or non-Indians and the tribe, there's a lot more limitations on what the tribe can do to regulate that area now. Although fortunately for a lot of what you'll be doing, that you do with the development work, it's a situation which falls into one of the key exceptions that allows for more tribal jurisdictions. So I'll talk about that as we go forward too. So the key case that came out in 1981 that really kind of limited the authority of tribes over non-Indians is called Montana versus the United States, or the Montana case, and they also talk about it as being the Montana rule, because it has such broad effects. Basically, this one case in terms of kind of determining what kind of authority the tribes have over non-Indians in any country. And they set a precedent basically that what is necessary, that the jurisdiction of the tribal government is basically only what's necessary to protect tribal self-government or to control internal relations. So basically limited the ability for tribes to regulate non-Indian activity in Indian country or on, on their reservations, basically. And so the basic rule is that there's not jurisdictional authority for the tribe over non-members, but there are two exceptions. They're important exceptions, and the one that is probably mostly important to you all is, fortunately, it's pretty strong and relatively broad as long as you have a consensual relationship. So the second one, though, is much more limited. I'll talk about that too, but has really limited the ability for tribes to regulate when there's not a consensual relationship between the tribe or its members and the non-Indian. So, but basically, the Montana case notes that tribes may regulate, through various means, including taxation, licensing, and just regulation in general, the activities of non-members who enter into consensual relationships with the tribe or its members in measures such as, commercial dealings, contracts, leases, or other arrangements. So what that means essentially is that when you're working on projects and you're entering into contracts with, construction companies and others that will build the projects, because your tribal housing authority or perhaps the tribe directly entered in those, the tribe can have regulatory authority over that, which is good, obviously, and important. But if someone just walks through the reservation or comes on the reservation and causes some activity to occur, some harm, then you kind of fall in the second category, which is really only for those activities that threaten or have a direct effect on the political integrity and the economic security or the health or welfare of the tribe. The big issue there is just how courts have interpreted that much more narrowly. So if you have a contractual relationship, which is what most of your activity with non-Indians is, fortunately, the tribe has retained basically jurisdictional authority over that. For things where there's not a contractual relationship or consensual relationship, which include anything else, if any activity occurs in the reservation, then it's a much more difficult test to meet for tribes to have jurisdictional authority to really control over what's going on. So that's the basics of that. So a key issue is that, fortunately, I think it's helpful for tribes and for tribal housing authorities because of that first exception allows for tribal regulatory authority over your contractual relationships, and you therefore can be regulated by the tribe. It'll be in tribal court, likely, as long as you don't change that in your contract, things like that. The second big issue for development is to be aware of is the idea of sovereign immunity. And the good news, first of all, is that housing authorities, because they're considered what are called arms of the tribe, which means that they're, because they're controlled by the tribe and they're doing work for the benefit of the tribe, they've been found to have, the full extent of the tribe's sovereign immunity. And tribes do have, sovereign immunity. It comes from different reasons, but it's basically like the state does and the federal government does, and local governments too have that. But one thing to be aware of, and I think most of these have been cleaned up by now, but there was a HUD kind of 1976, basically with kind of boilerplate, so kind of form or generic Indian Housing Authority ordinance that includes in it language that says the council, so I mean the tribal council, hereby gives its irrevocable consent, allowing the authority, so the housing authority, to sue and to be sued in its corporate name. And there's a Ninth Circuit case that noted, it didn't really decide the matter, but it noted that the issue of whether this sue and be sued clause effectively is a waiver of sovereign immunity, and that it remains a live issue. So because of that, it's important that if your ordinance does say that, to have it removed. You just not have a potential for a waiver of every contract you sign go through that way.
Hey, John.
Yeah.
Looks like we got a question in the chat.
Oh, great. Great. Thank you.
Yeah, he asked, are there bonding issues on restricted tribal land? This was back before you were started talking about sovereign immunity.
Hey, Michael, are you able to, maybe if you could maybe just unmute and ask me that. I'm not sure exactly what the context of the question is. So maybe if you could ask me that'd be great. We could talk about it. That'd be great.
We had a question from one of our upcoming bidders, I guess, in trying to secure performance bonds. But the issuance of that bond was questioning whether this is on tribal land or not. And I didn't know if if you encountered that and whether it was going to be a cost increase, or that are they seeing it as a cost increase when they do that? You know, what kind of issues are they actually running into? I'm not really sure.
Yeah, I'm not so sure about that, because we've had projects where they've explored bonds. A lot of times we've worked, through on projects of, do we really need a bond or not? And because it'll add to cost and add to the cost of the project. But I haven't heard in that context that it's more expensive to get the bond because it's on, let's say, trust land or other restricted land. It's more been just, it's expensive to get these bonds in general. So I'm not sure if their bonding company has said it's going to cost.
Legal issues in Oklahoma, a lot of legal issues and precedents already are said in Oklahoma here recently, and that's probably where it's coming from.
Oh, that might be an Oklahoma issue, yeah. With I think people are a little more heightened on that issue because of the Supreme Court case. I bet, yeah. But I'm not sure though whether or not it should be more expensive, especially if they get the same assurance as they would normally get. So I'm not sure on that. It'd be interesting to hear what they have to say about that, if it's actually somehow raising the cost.
Okay.
What the logic is there. Great, thank you for the question. And so I think I was just saying that, because of this, because of the fact that you have an old ordinance that's from this HUD form ordinance, you might have a sue and be sued clause, that it's important to remove that and to make clear in the ordinance that, you need to get a waiver on each action, and that the waiver has to be approved by the board of the housing authority. So that's something to just be aware of, especially if you're the housing director, just to make sure or anybody with the housing authority, just make sure that you're aware of what your ordinance says in this area. So especially so you're not doing a lot of work to try to avoid a waiver or to limit what's going on, and then realize that, hey, there's an argument that there's already been a waiver. And then this slide just kind of goes into that, and this is probably important. This is, important to know about, or is it an important principle, I guess, for all kinds of sovereign immunity, that there's, sovereign immunity has obviously become an issue that is litigated a lot, because, basically, if there's a real dispute going on, the party that wants to sue is going to try to figure out ways to get around sovereign immunity. What's going to happen is they would sue. There'd be a motion to dismiss, probably with limiting to make clear that we're not agreeing to jurisdiction, but we just want to raise the sovereign immunity issue. And then out of that has come a lot of briefing and decisions. Basically, I should say, since it's of course, they've had to address where you have two parties, one wants to, the second party saying, no, you can't sue us. And so obviously there's a lot of legal arguments that come up in terms of ways that the suing parties trying to get around that. And so there's been a number of decisions out there that make clear that there are certain limitations. Like the first one is this ex parte Young doctrine, which is basically that a tribal official in this case, but any official, if it's the state or whatever, can be prevented from taking action that's illegal or unconstitutional. So if they can create an argument based on that, they may be able to get some kind of injunctive relief. Just means instead of getting money, you get a decision that forces something to happen, either to happen or not to happen. Basically, so they might be able to get something that causes the tribe to not, or the housing authority to take action or not to take action, that they're at least requiring the official to take action or not to take action. The similar kind of idea is naming tribal officials individually can be a method to try to get around that, and to perhaps have, probably again, more so injunctive relief to have certain activities occur. There are I think there's an Alabama case that says that, that the immunity does not apply to torts. The argument for that is basically that, the party that, what a tort is, first of all, to make sure tort, there's contract claims, the two basic claims that are out there that relate to, that are what are called common law claims, meaning that they're based on court law versus like a statute or regulation or something like that, are contract claims. So a contract claim would be a claim that, that somebody breached the contract basically in some way. The tort claim is somebody gets injured. There's not a contract related issue, but somebody injures somebody else or causes property damage or whatever, at least arguably. And so at least one Alabama court has said that it doesn't apply, sovereign immunity doesn't apply to tort. So it wouldn't be your contracts with your developers, but it would be applied to somebody getting hurt on the reservation, let's say. And again, the logic for that would be, for not having sovereign immunity, is that that person didn't know that you had sovereign immunity. They didn't, they didn't enter a contract with you. They didn't, there's no consensual relationship. It's just that they got hurt, but that doesn't necessarily, in most areas, that doesn't necessarily knock it out. And then there's also, sometimes there'll be suits over off-reservation interests in land and arguments that they should be able to get kind of attached to that interest in the land. So there are chinks in the armor. There's also chinks that occur based on, whether or issues that arise based on whether you've waived it or not. An important set of cases talk about situations where there's, for instance, arbitration clauses in contracts, and where there may be no express waiver in the contract itself, but they refer to, let's say, AAA arbitration rules, which then allow for enforcement of an arbitration decision in a court. And the courts have found that actually is a waiver, because you've agreed to arbitration, which by the rules of the arbitration naturally leads, or is a situation where you've agreed to, by signing under those rules, to be sued in court, or to have a arbitration decision enforced in court. So it is really important also to be thinking about, it's not only like we didn't put the words "we waive our sovereign immunity" in the contract, but also whether any of the contract provisions that are in there, and many of the contracts you'll get, as you are aware, if it's from a developer, a contractor, or whatever, will be on their form contracted first. So it's important to have the legal review occur to make sure that you're comfortable that you're not waiving sovereign immunity that way. Another issue is just that, in addition to these kind of chinks in the armor and being kind of wary that you're not mistakenly waiving your sovereign immunity, is just the issue of, oftentimes you need to waive it in order to have a transaction occur that's important to you. So if somebody's, doing a lot of work for you, for example, and it's and then they have enough leverage to say, well, we need to be protected on this, because their side of the fence is that we're in a contract that you can enforce against us. We want to be able to enforce it against you. Then you need to think about, how do we waive it, and what's a way to do it in a way that makes sense, or do we move on to the next contractor who may also raise the same issue? So one thing to point out is that oftentimes, your board will have set up principles on when a waiver would occur and what the terms of that waiver would be. And whether they do or don't, it's probably important to be aware of this idea. One, you don't waive it unless you have to. Two, and this is often the case for if a tribe or housing authority has kind of policies on this issue, that you would kind of push towards tribal law over state law for what's applied in the matter, especially where there is tribal law. Oftentimes there may be language that says that in the contract that tribal law will apply unless there's not tribal law, and then we'll look to the relevant state's law where the reservation is located. There'll also be oftentimes waivers, but then with the waiver, then the matter goes. The parties agree that the matter would go to tribal court versus state court. And then finally, I think a lot of times you'll see under the waiver, that's maybe the form waiver the tribe or the housing authority has, or maybe if you don't have that, just what you put together as kind of a middle ground will be having arbitration occur with enforcement in a tribal court. And that's something that is oftentimes easier for the non-Indian contractor to agree to, because they know what about the arbitration rules. They've been through arbitration in the past, or at least understand how it works. You can select an arbitration kind of group, basically like AAA or something like that, so everybody knows what's coming kind of at them. And then once the arbitration is complete, then you would be enforced in tribal court, which would, they oftentimes are being willing to agree to that, because they know then that they'll be coming in if they win the arbitration with an award that the tribal court should recognize. And if they lose, then the tribe would just be enforced in tribal court, but the tribal court would not be making the underlying decision, but just enforcing it. So bottom line is, I think it's really important to be aware that, that sovereign immunity would apply to you. Make sure you're not waiving it by mistake. And then if you are waiving it, do it purposely, and make sure you're working with the tribes or the housing authority's attorney to make sure it's done correctly and within the policy of the housing authority. And so the last area I kind of wanted to cover on just kind of general, and this is obviously there's more issues in this, but these are the kind of three basic areas, really kind of key areas or basic areas in terms of Indian law and tribal law applying to the kinds of stuff you do, are the need for federal approvals for basically a lot of kinds of action that might in some way affect the land. The reason for this is obviously we're talking about trust land or restricted fee that the federal government is, kind of is the owner of, and it is acting as a trustee for the benefit of the tribe and with respect to the land. So there's been a lot of rules set up to make sure that that land is protected. So in a lot of ways, there's good reasons for this and ways to protect. It helps protect reservations. On the other hand, it also can limit development that you're trying to accomplish for the benefit of the tribe and its members. So you got to kind of be aware of these things and think about them and work through these issues. The first one is just, it really doesn't probably apply to you all that much, but it, basically any kinds of sale or other transfer of trust land or restricted fee land or restricted land requires the approval of the federal government. That's to protect, tribal reservation lands and reservations from being kind of eaten away by having transfers occur. So, but the second one is probably much more important to you all, especially if you're doing any kind of like low income housing tax credit project or other project where there's some entity that's not just the housing authority itself that will own the project, because then in order to own the project, like a housing tax credit project, the housing tax credit LLC that's set up, and we'll be talking about housing tax credits later on, so we can think about this, in that context a little bit more too. In order for it to truly own the home, let's say, or a lot of times have an energy projects too, if you're with a partner or a taxable partner to take advantage of certain tax benefits, in order for that energy project to be owned by that entity, it has to have access to and control of the land, basically enough to show that it owns the home or let's say the solar project, as opposed to the tribe or the housing authority. And so that may require a lease, and especially for a house, it probably requires a lease because you want it to be there for a long time. We can talk about later on when we get to energy stuff, and especially if there's ways of getting the tax credit more directly now for solar and other projects, but there still may be reasons to go forward with an investor in certain situations. Then you need either a lease or perhaps you get an access permit, and we can talk about that then, about how you can kind of work around these issues. But especially in the housing context, you'll need to have, if you have a housing tax credit project, you'll need to have a lease of the land to that housing tax credit group, and that requires both the tribal consent, or the tribal housing authority consent if you have the authority to sublease land from your tribe, but you also may require BIA approval, especially if your original BIA approval for the lease of the land to you, let's say, did not include the ability to sublease. So with the caveat that all not needed if you have what's called a Hearth Act ordinance. That's an ordinance that applies with the Hearth Act, which then allows, if you have a ordinance for that, and basically what it requires is a proper environmental reviews to occur, but by the tribe itself versus BIA. And then if a lease is, you know, approved by the tribe or the housing authority, it would be considered approved by BIA. So that can be a very important element of your tribe's ordinances, because it can allow for more flexibility in doing leases. And we've been working with tribes that have those, and tribes that don't, when they don't, we have to figure out how to make things work. The big thing there though too is that if you have to go through BIA, you need to, as you're probably aware, you know, have a good relationship with them to get things done, but then secondly, have enough, be on the same page or understand the timeline for them to get their work done to approve the lease. The next area that requires federal approvals is our rights of way, you know, so for a roadway going through the reservation, for electrical utility lines, for natural gas lines, for oil pipeline lines, stuff like that. Also for lines to allow for basically broadband, if it's coming through, you know, through hard wiring and stuff like that to come on the reservation. So all those things for a right of way require BIA approval. It's under the Part 169 regulations, and we'll talk about that in more detail, because this can actually be an area where tribes can get sometimes very significant revenue and can be very helpful for you know, serving as cost share in a lot of these projects, because, you know, for both the tribe and the housing authority, when they are pursuing you know, tribe projects that benefit the tribe and its members, can oftentimes get, we'll be talking about this a lot to, you know, to today, in the next 3 days, next 2 days, how that money can be very helpful, and there's a lot of good sources, but almost all of them require some kind of cost share. So this is going to be an important way of getting money for cost share for projects. It can be also important just for tribal budgets in general, but can really help tribes make projects work. So we'll talk about that as well. And then finally, encumbrances also require federal approval. So let me go to the next slide, which goes into that in a little more detail. So an encumbrance is, you know, so you can, there's the things like, you know, we talked before, like leases and rights of way and selling the land. But in addition to that, there's the issue of, you know, if there's any claim that could be against the land, any lien, any right of entry, those kinds of things, easements, mortgages, and anything that can give somebody else either right away, like on an easement, ability to for exclusive or nearly exclusive control of the land, or on the event of some occurrence, like on a leasehold mortgage, that occurs obviously if there's a default of the mortgage, then the bank could take over the leasehold interest in the land. So any of those things that are like that where there's that lasts more than 7 years, and where the agreement hasn't been approved by other legal situations, like for a lease or a leasehold mortgage, then the BIA needs to approve that encumbrance. So I think it's important to be aware of it whenever you're looking at any kind of encumbrance, any kind of limitation on the land usage. You need to be thinking about, do we need BIA approval for this? Because it's a lease, you do, unless you have a Hearth Act ordinance. If it's a right of way, you do, but also any kind of mortgages, things like that, do as well. Any kind of liens against the property. So that's another area to be important to be aware of. It may not come up a lot of times, but it's good to be aware of that as background as you go forward on projects. So I think that can kind of concludes the federal Indian law stuff that applies. So the federal government being involved in your projects from a legal perspective, including I guess the issue of, you know, sovereign immunity as well, and the tribe's authority to regulate projects. But now we'll get more into, you know, the tribal infrastructure to develop and support projects. And Bill will cover that. And I'll turn over to Bill now. Thank you.
Thanks, John. And I think it would make sense if we take a 10 to 15 minute break following this section.
That sounds great. Yeah.
I might break up right in the middle in the morning session here. So I'm going to continue some of the things that the tribe can do now to sort of support, enhance tribal sovereignty, support, and to facilitate projects on tribal land. And that includes a discussion of how to get a Hearth Act approval, but also talk about different ordinances. Generally speaking, a lot of tribes don't have enough regulatory authority established through tribal law, and there's really opportunity to enhance that if you do not. And so we'll provide some examples of that. I'm going to put a link in the chat for your reference. But you want to be able to assert tribal sovereignty and put the tribe in position to enforce its own laws. And in any case, if you can eliminate the participation of BIA in approvals through those types of ordinances, that just fast tracks that, and it removes a third party from something that should be in your control. So it's just a general good practice that we'll speak to. So obviously, these types of ordinances that we'll cover are helpful in the development of infrastructure and housing. All of these initiatives create leverage with tools that are at your disposal, and they remove barriers for development, which is what you're seeking to do in a plan. These initiatives may not on their face appear to be a development tool, but they really do create a lot of leverage, and give some examples. So let's see here. I have control there. So there's a number of tribal laws that can support the development of projects on tribal lands while protecting the tribe and its tribal land resources. There's really 4 categories. John touched on the Helping Expedite and Advance Responsible Tribal Home Ownership Act of 2012, the Hearth Act. So you want a Hearth Act compliant leasing ordinance. We'll talk about that. We'll talk about utility ordinances and how to best practices regarding those. Implementation of tribal commercial or corporate codes and how that can help with project development. And also environmental protection ordinances. Those can also assist and provide more control to the tribe regarding approvals. So John touched on this, but the Hearth Act became effective in 2012, and it provides tribes with the right to lease lands up to 75 years without the approval of BIA. So John gave like a general rule that 7 years or those types of leases do require BIA unless you have one of these approved ordinances. And in the chat, I shared a list of approved regulations from tribes, and this is, if you look at the per year since this was enacted, each year there's mostly additional, you see a rise in participants on this. And these are commercial, residential, industrial leases that can be approved. This slide is out of date now. There's 83 tribes that have been approved as of the end of this last year, and at least 20 or so cover residential housing, at least based on the characterization on their website. So this is a growing area where entities can look to see, hey, does this fit? And in the link I shared, there's some examples of what these look like. So please feel free to check that out. So the Hearth Act compliant leasing ordinance must be consistent with federal regulations 25 CFR Part 162. And those requirements are identification and evaluation of any significant effects of a proposed lease on the environment, public notice and opportunity for comment on significant environmental impacts associated with a lease, and response to public comments before a lease is approved. So importantly, the Hearth Act compliant leasing ordinance allows the tribe, not the BIA, to define what significant effects and what that means and what public notice means. So this allows the tribe to control the environmental review and to focus on the effects that it's most concerned about. It also allows the tribe to ensure that the appropriate public input is received and considered. So where the federal government has already undertaken an environmental review in connection with a federally funded activity, the tribe could rely on that review to create some efficiencies, save time and resources. So there's there's ways of writing this type of ordinance that it fits your tribe's priorities, but also may save time and money if it's done correctly, so you're not creating redundant processes. So another tool I spoke about is the development and implementation of a utility ordinance, and that creates tribal utility and more authority to operate. This strategy helps the tribe fit in the federal and state processes more regarding projects typically undertaken by project utilities. And a utility ordinance can provide the legal foundation for tribal water, electrical, and other utility operation. In addition, it can help address state law limits on electrical energy generation projects, which we'll speak to later in this presentation, likely on the third day. But for example, state regulations may limit third-party ownership of tax credit financing, and the tribe would like to utilize such financing for projects on the tribal lands. The utility ordinance may help provide a legal foundation for such financing. Obviously, you'll like I spoke about, you'll hear more about energy tax credits from John and Mark later, but the recently passed Inflation Reduction Act allows tribes to directly receive credits for certain energy projects. We'll speak extensively about that, but that eliminates a barrier that previously existed. And the main point is, in some situations, it may be more beneficial to partner with a third party to receive additional funding for tax credit financing, and therefore having legal support for such an arrangement will be helpful. Oh shoot, I missed one other thing. The utility ordinance can also be helpful in regulating non-tribal utilities doing business on tribal lands. So, for example, a utility ordinance might require reasonable terms for net metering and interconnection of renewable energy facilities on the tribal lands to facilitate tribal development of renewable energy projects such as solar and wind. So tribal, commercial, and corporate codes can also assist on tribal land development. Think joint ventures with non-tribal entities. Commercial codes can provide an option for setting up tribally chartered LLCs or corporations for joint ventures for investors. These codes may potentially provide an ability to better position tribal projects with respect to sovereign immunity and state taxation issues. It's important to note, though, that investors may be more comfortable, at least initially, with utilizing state chartered entities, especially if they haven't done projects like this before with you or other tribal entities. And accordingly, it's important to evaluate the pros and cons of utilizing a tribally chartered entity versus a state chartered entity for any joint venture project, because obviously that has to do with your partner and their preference for that sort of endeavor. Commercial codes, baseline, they can provide tribal law basis for perfecting and enforcing lien rights on tribal lands, which is valuable. And then turning to the other category of ordinances, environmental laws, they're extremely important for reservation development and for ensuring the tribe's environmental priorities and values are appropriately considered with respect to that development or any development. A tribal ordinance that provides for environmental reviews as a counterpart to the NEPA or Federal National Environmental Policy Act reviews can elevate and incorporate the tribe's own environmental and cultural priorities and value with respect to environmental review. It also allows the tribe to set its own procedures to satisfy environmental requirements for issuance of leases and right-of-way. Tribes can also create ordinance to specify specific procedure and protection regarding impacts to reservation resources, depending on where you are. For example, tribes can develop wetland permitting requirements and stormwater permitting requirements that protect critical reservation resources, while also providing a more efficient process for review of those projects. I believe that brings us to a break. So, John, do you want to take 10 or 15?
Let's see, it's now 27 after the hour. Why don't we start again at 40 minutes after the hour, so kind of in between the two, and then we'll know when to come back. Great.
All right, we'll catch you all real soon.
All righty, thank you, guys.
And Bill and I were just talking about, there was a question raised in the chat from Brad Frizzle, noting that I think when Bill was going through his slides, they would note reservation, but he was using the term tribal lands. And I don't think he was trying to point out any distinction between the two, but I guess maybe it's a good opportunity to kind of talk through what tribes have jurisdiction over. So clearly they have the jurisdictional stuff we talked about at the beginning, that I spoke about, I guess, with respect to jurisdiction over members and non-members, especially non-members, was in general talking about, a situation where the tribe has regulatory authority, at least generally already, and that those areas tend to be, the trust land themselves. And then if it's within a reservation that has exterior boundaries, that could also include the fee lands, owned by the tribe, and the fee lands owned by the members, as areas where the tribe generally has some jurisdictional authority. And that's, I think, what, basically Bill was talking about when we're talking about, putting in place ordinances where the tribe has regulatory authority. It would typically be over the trust land, and then because some tribes don't have exterior boundaries, so at least for those trust lands or restricted fee lands that are set, and then the lands that are owned by the tribe or the members, whether those are trust or fee status. So just let us know, Brad, if there's anything else you'd like to talk about in that area. But it's an important thing to be aware of, kind of what areas of land would the tribe typically have some jurisdictional authority over, or jurisdictional authority, I guess you'd say. So now, if it's okay, I want to talk about this last kind of area of the legal infrastructure section, which is dealing with right-of-ways in a little more detail. And the reason why we're doing this again is because with the passage or the promulgation of regulations under the Obama administration regarding rights-of-way, tribes have a lot more authority in this area than they did before, kind of self-control over these issues. And it can be, because of that, it can be a very good opportunity for tribes to both exercise their jurisdictional authority generally, and to make sure that these rights of way have terms that they agree with, that they want. And then secondly, can be just probably equally important, or perhaps more important from a financial point of view. These can be great sources of significant revenue for tribes that go on for years and years, and therefore can be an important part of kind of both cost share for projects, because there's always a cost share element to these grants that are available for tribal and for housing projects, and then secondly, just to have more money to the tribe for its operations. So we thought it was worthwhile to go through this in a little more detail, mostly because of the importance of it for tribal authority, and then also revenues to the tribe, which can be really helpful for your projects. So anyways, I want to go forward now and talk about the ability to get significant annual payments from rights of way on the reservation. And there's three ways this can occur. It's really mostly the first two, and the last one's more of a leverage point to get the first two, especially for getting the right of way payments. So if there's a right of way that doesn't have an approval for the non-Indian basically party to be there, or there's just no right of way, so it could be an expired right of way this would apply to, or something that doesn't have any right of way that's properly authorized. The tribe can then basically raise its hand and say, you need our consent to be here, even to ultimately get the BI consent for you to right away to occur, and we get the ability to set the annual fees. So from that, if there's an expired right of way or a right of way that was just never properly approved on the reservation, that can be very important for getting significant revenue, and really long-term revenue, because it could be a fee that occurs every year, basically. So it could be annual charges that occur. And then even for the rights of way that are approved, they're properly, where the third party, the non-Indian party has the right to be there, the tribe can charge property taxes. This relates a little bit to the issue I talked about before, that the tribe's general regulatory authority is on the trust lands and restricted fee lands, but it also includes for the tribe with boundaries, the member fee lands and the tribal fee lands on the, on the reservation. So that can oftentimes, create a lot more land upon which the tribe has authority and therefore can charge property taxes. And again, you can charge property taxes even with the right of way that's properly approved, because that's a separate thing. It's just the, the ability to, tax equipment and structures on the tribe's land, which you can do, and in which the BIA, through its promulgation of the regulations under the Obama administration, made more clear, which is helpful too. And then finally, if there's an entity that's on tribal land without authority, the tribe can also assess trespass damages, and they can create their own tribal laws that relate to that. At least that's what the BIA says in the regulations, in which we've used as leverage to get the other payments made in some cases. So the regulations, the Obama administration regulations, came out in 2015. So they've been out for a little while now, but I think a lot of tribes are still not perhaps fully aware of them, and also are maybe not taking full advantage of them. So what it basically does is that it's really written in a way that was trying to, in this context at least, create more tribal sovereignty over land issues, basically. So in particular, right-of-way issues. So what they did was they both kind of hurried BIA up. So they have timelines for BIA approval, so they're not kind of sitting on matters, so the tribes can actually get stuff approved they want approved. And they prevent BIA from disapproving a right-of-way that the tribe is consented to unless there's a compelling reason to do so. So really kind of letting tribes take the lead on what they want to consent to and what they don't want to consent to. As you might be aware, in the past, a lot of times what would happen is that BIA would just simply come, they would negotiate the deal with the non-Indian entity and come to the tribe for kind of rubber stamp approval. Now it's kind of reversed, where the tribe's consent is what is key. The non-Indian has to get the consent of the tribe, and then BI will generally approve it as long as there's not a glaring kind of concern going on. And that also gets into deferring to tribal landowners or Indian landowners in general on these issues. And then the regulations also do a good job of clarifying the tribal jurisdiction over the lands subject to a right of way, which is important again for things like taxation. So it helps bolster the position that the tribe can both regulate and tax these right of ways, which is again, I think, consistent with Montana, because there's a consensual relationship. The only way that they're allowed to be there without trespassing is through a consensual relationship that involves the tribe for the right of way to be used. And if that's the case, then the tribe should be able to tax and regulate the right of way as well. And then, but basically the bottom line is it allows the tribes and individual landowners to negotiate the terms of the consent, which means the tribes can set the fees, especially on trust lands that they own, as well as fee lands they own. And that's because state takings law can't override that consent. So they can't, let's say electrical utility or gas utility or gas pipeline owner can't just take advantage of state law for taking the land. That doesn't work for them with respect to the tribal land itself, at least. So it gives tribes a lot of negotiating leverage on this issue, essentially. With individual tribal member lands, unfortunately, that doesn't necessarily apply. The takings laws can apply, so those are generally done under agreements that are not quite as kind of super favorable to the tribes or to the tribal entity or the tribal member as they are for the tribes itself. But I guess what I'm focused on now really is what the tribe can do, and therefore what can be raised in revenue, and therefore what can be available as tribal resources for projects on the reservation. So there's a question in the regs. These regs are written as, like a lot of them are now, questions and answers. How much monetary compensation must be paid for a right of way over across tribal lands, and then it's really whatever the tribe negotiates for, what the tribe gets, basically the tribe, as long as the tribe makes a clear statement that it has agreed upon compensatory or compensation that is satisfactory to the tribe, that it waives what's called valuation. That would be under a normal right of way, which is normally done through a taking or with the background of a taking occurring. And taking just means the authority to actually take the land that's under some statutory authority for, let's say, the utility, where they pay, fair market valuation, and fair market valuation would be a lot less than what the tribe would get in this context. What the issue with fair market valuation is that they're just taking or using typically a relatively narrow strip of land that goes through whatever area it is, in this case on a reservation or on trust land, and it it's just to put a pipe there, or to put a let's say electrical line there, or put it in a broadband line or whatever. It's oftentimes unclear if there's much of any of a demonstrable loss in value that occurs. If it's above ground and impacts development, that's where you might get a fair amount of money, but still it's not going to be anywhere near what the tribe could set as its own kind of right-of-way consent fee. And typically if that occurs under taking, it's a one-time payment. It's relatively small. We've been the good fortune workers in tribes that have been able to, especially where the line is, let's say a transmission line that goes to the reservation that's important to the utility, to get a very large annual payment that's repeating, that goes up in value with inflation, stuff like that, and can be an important source of revenue for the tribe generally, and also to help make sure the tribe can get these kind of key projects to occur, but where there's, let's say, federal grants or other grants or tax credits, but there's a cost share, and oftentimes the cost share becomes a limiting factor. So this is a really key use of those funds too. And then third, if the tribe would have to state that it's has determined that accepting these agreed upon compensation and waiving valuation is in its best interest. And obviously, again, if the tribe is making the decision and it's able to set the fee that's very high, it can obviously easily make that statement too, that it's in its best interest, because it's clearly is in its best interest, much better than going under a traditional kind of state law or the prior system where the use of the right of way would be obtained for a small one-time payment. And so the compensation is addressed directly in the regulations as well, that they'll defer to the tribe's decision to allow for any compensation negotiated by the tribe. Again, so in theory, this could be the tribe says, we really want this line to be on the reservation, and we'll take no compensation or very little. But the big use of this, I think, is really, the ability to have leverage and to get significant compensation that occurs annually every year. So the regulations also address trespass situations, where there's an unauthorized use of the land, which could either be, has always been unauthorized, or it was authorized, which is typically the case, but a lot of times these have expired because they're 25 or 50-year rights of way, and then folks just kind of tend to forget about them sometimes. And so we've worked on projects where the tribe has, there's utility lines going through the tribal reservation, and these things are now becoming expired, and that then the tribe is able to raise these issues and then get, a lot of times very, very significant payments for that, because especially if it's a transmission line, meaning it's transmitting or sending large amounts of electricity across the reservation, or large amounts of natural gas, or even oil, the oil pipelines. Those lines that are existing are oftentimes very important to the utility or the owner operator of that line, because it brings product from two sides of the reservation. It could be all throughout the state in which you're in, or even all throughout the region. And so they've oftentimes been willing to, especially for natural gas pipelines, I think, especially, as well as oil pipelines, things like that, it's worth it for them to pay a substantial fee to the tribe just to stay there and to operate. This also then allows the tribe to, put in place safety requirements, things like that, to make sure that the line's in good shape. It's not going to have issues, that they address them right away, that kind of stuff. And so you're not required to do this, but what we found is real helpful for tribes is to create their own right-of-way ordinance then, so they have a framework for the consent that the tribe might provide to the project. That would be either, it could be a new project or it could be an existing project where the right of way is expired. And where the compensation can be set under some sort of terms that the tribe agrees or believes is fair but reasonably high, basically, so rather than having to negotiate from a rate with them in each case, the tribe could set values that are significant, and that it would say that if any pipelines coming through here of a certain type or any kind of electrical line of a certain type, that we're good with that, and it makes clear what the law is. It helps create a situation where it's harder for the utility to say, well, can't you just, why are you charging so high? You just say, well, it's in our ordinance, and we create an ordinance that's not that dissimilar from property tax ordinances. We set it on certain objective, fair principles, and you just got to pay it. And just noting here again that that the big thing about these right of ways is not only the ability to get one-time revenue, but to get it for however long that the utility line or other right of way user is there. And then it could also set up in the ordinance, just like the BIA's regulations say, that the tribes decides whether to consent or withhold consent. Typically that'd be through the tribal council. So it could be that even if somebody would meet the payment, if you think they're if the tribe believes that there's going to be problems from the line, let's say it's an oil line, it has leakage occurring historically, or similar lines of leakage occurring, the tribe could decide we're not going to allow them on the reservation anymore, or if they weren't authorized it, they're not allowed to come on now. And then basically under these ordinances, as I noted before, if it's not authorized presently, either that it was never authorized or the authorization is run out, the tribe can set the right-of-way compensation fee. And that fee, these are things that we've worked with tribes in putting in place that we think probably make sense. There's other ways of doing it too, because you can set the fee based on, in theory, on anything, but things that seem to be reasonable and that would the utility can kind of understand, at least even if they don't like it, would be considering the length of the line. So how many feet long, let's say, is the line, and then thinking through what the throughput of the line is. So if it's an electrical line, that's typically in terms of voltage. If it's a gas or let's say oil line, natural gas or oil pipeline, that would typically be the diameter of the line. There could be other things said. It could also just be based solely on feet. But the one thing about it is that the more the line puts through, the more valuable it is to the utility, the more reasonable it'll seem to the utility to have whatever fee you have. So that's one reason why typically when we work in the tribes, we've been talking about. But then when you're thinking about the fee, the amount of fee that will be considered at least okay by the utility, they're obviously not going to be in a hurry they don't necessarily want to pay anything, but that will be considered okay by them. Will depend on the circumstances. So if it's a transmission line, meaning it's a bigger line and it kind of carries energy throughout a large area that includes typically off reservation as well as on reservation, and perhaps where there's actually no service on reservation. A lot of times these transmission lines just go through reservations, they don't really serve the reservation. In that situation, it's probably easier for the tribe to have leverage to get a higher fee, which again then can play into these kinds of standards that would be set on the voltage of the line or the diameter of the line. The bigger the diameter, the higher the voltage, the more you could charge, and that the utility is likely to be agreeable to. Also, if it serves customers that are off reservation as well as on reservation, and it's really important, it's a line that carries, say, a lot of power or energy to areas that are off reservation, they're probably going to be more open to the fees and not complain as much, basically. If they have alternative ways of going around the reservation, we actually had one matter where the utility decided to move the line. They still need to pay the fees until the line is moved, but they did have an alternative route, and therefore that was somewhat of a limiting factor. So things like that, things that are, whether it's alternatives or not for the utility, can be an important factor in what they're willing to accept without fighting too much. And so the idea here is obviously to have, we don't get the revenue in the tribe, but we don't want to be in a long-term dispute. So that factors in a little bit in terms of what kind of fees to charge. And then just noting that this revenue can be an important source of revenue to fund projects for the tribe and its entities like the housing authority. And important, especially because, you know, grant funds tend to be cost share, still cost share involved in projects. So with the right-of-way ordinances, this slide is a little bit repetitive, and we can take it out of the next presentation, but it's really, again, we can set the fees based on the tribe can set fees for unauthorized lines, and can also include, you know, penalties for trespass, and or annual fees for trespassing that will then encourage the out of compliance utility or other line user or holder to agree to get the consent and just pay the normal fees. So you want to have typically a backup trespass provision too, so that things are worse if they don't comply, and to nudge them towards compliance. You don't want to, again, have fees that are so high though either that you're going to have a lot of fighting, but you want enough leverage to make sure that they basically pay the fees they're supposed to pay. And then the other point again is under these ordinances, you could also have as a part of it a tax ordinance, a property tax ordinance that has property taxes paid regardless of whether there's valid right of ways, and also where the property taxes are paid to the tribe, even on, let's say, member fee lands and member trust lands, and not just tribal lands, but it would also include tribal fee as well as trust lands, as well as all those lands, as long as all those lands are on a reservation with boundaries. So you can say that that's all under the tribe's jurisdiction. Again, just noting that these can be really important sources of revenue that can be used to help finance, you know, the kinds of projects that we're talking about. And again, we'll be going through these grants a lot of times and noting that there's, in a lot of cases, talking through what the remaining cost share is, and this is the key thing for getting the cost share covered. And then on these ordinances, so you'd want an ordinance, if you're putting one in place, to charge the property taxes on the right of ways, and apply to for the property tax ordinance, apply to all the lands within the tribe's jurisdiction, including, you know, fee lands owned by tribal members within reservation boundaries I talked about, these maybe, you know, based on the value of the assets or the size of the facility. So what you might want to do is, if it's a line, you may want a similar kind of approach, but perhaps somewhat lesser in charges that could be based on the length of the line going through, the voltage for an electrical line, the diameter for a gas line, things like that. So that your charges appear to make sense and that they're easy to apply to, because if it requires some valuation, that will require another step involved, and the tribe may or may not want to do that. And so the property tax ordinance can provide a revenue stream both for lines that have authorization and lines that don't. So it can be really important to tribes that let's say have a lot of lines going through the reservation for electricity and other things, for natural gas, for oil per se, but let's say they're all existing right of ways. This is an important strategy then to be able to get revenue from those, even if they have existing right of ways. And you'd set the taxation, the same economic and strategic factors involved as for the right of way fee. You're trying to make sure that you get enough revenue to the tribe, but also that they're not likely to fight it a lot if we can do that as well. So the bottom line here is that we want to set the fees high enough to get a fair amount of compensation to the tribe, or actually even more than a fair amount. So hopefully they're doing well from it. But we also don't want to have triggering years of expensive litigation with the right of way user. So getting that proper balance is probably the biggest thing here, making sure you can get the revenue to the tribe. It's long-term revenue. It can be used for a number of projects, but that it's not a drain on the tribe either. And then, so you go through those same factors. I don't know if I necessarily need to go through them again, but when you're considering what's reasonable, you want to think about, is this a line that serves off reservation stuff too? And how important is the utility, things like that. And the one thing I should point out is that even we worked with a tribe that had lines on its reservation, both like broadband type lines and electrical lines. And they didn't serve anybody else than the reservation. They're all just local distribution lines, and they still were able to get, I think, what would be considered a relatively significant ongoing payment from both a settlement payment for prior, issues, and then going forward. It's not like it's tremendous amounts of money in that situation, but it at least provides some revenue to the tribe and allows them to regulate those lines as well. So that's basically it on this topic, I believe. So one more thing, I'm sorry. Another thing to think about, this we'll talk about this more when we get to the energy side of things. I think what you want out of energy is energy actions that are taken by the tribe as well as by the housing authority is to, both get better control over these issues, over, what kind of energy you're using, and but also what you're paid for energy, to bring that down and have control over that. And a lot of tribes have successfully created energy utilities, but one thing about the right of ways is that the tribe might want to think about, creating what we've often called here, I guess, a virtual energy utility for the tribe, meaning that it wouldn't need to then own or purchase from the utility all the lines coming through, the distribution and transmission lines coming through the reservation. Instead, it could regulate those lines, get property taxes and potentially right-of-way fees for those lines to make money off the lines, and then add in targeted renewable energy facilities that serve, homes in the tribal buildings on the reservation. And that way you kind of have, in some ways, the best of both worlds. You can, you don't have the responsibility for the lines, but you receive payment for the lines. The tribe does, and that money can be shared within the tribe however is appropriate. And then secondly, you can use the renewable energy projects and through programs that your utility may have, your existing utility, the non-tribal utility that serves the reservation, such as, we'll get this more detail in the energy section, but net metering and potentially things like community solar, if they're allowed, that provide real significant energy cost offsets from the solar and other projects the tribe might develop using grant and tax credit funding to help pay for most of those projects. So you could have a situation where you're regulating rather than operating the lines and getting money from the lines from the regulation, the taxation, and the right-of-way fees. And you're serving your facilities with these projects that you're taking advantage of, where you're taking advantage of the local utilities programs rather than having to set up your own program. So, but we'll get into that more later on. But this kind of shows how it can all work together to provide revenue streams to the tribe, and they can be used for tribal housing and other projects, and then to use the energy projects to lower energy costs. So now we've gone through now, how you put your development team together, how it should work together. Hopefully, and obviously there's tweaks that you would probably have for your particular organization of who's in your development team and how you pursue projects. But just give you a general sense, especially for the newer folks to tribal housing, about those issues. And then we talked about the laws that apply, both the regulatory authority of the tribe, understanding your sovereign immunity and protecting that, and at least not protecting as much as makes sense for particular contracts, and then being aware of the benefits of having tribal ordinances to have more control over your projects and to have them go through more smoothly. And then as part of that, the right of way where the tribe could actually make significant money from third-party interactions. But now we'll start talking more about the grants and the loan programs and other programs, tax credit programs, to finance particular types of projects. The first type we'll go through is infrastructure in general, which we're putting everything that's infrastructure related, at least in general, except the energy, which we'll do at the end, by the third day. Then we'll talk about housing, both rental and home ownership, how to fund that, for the programs to fund that, basically. So we want to talk about first are in the infrastructure context. This is the general thing we'll do for both housing and infrastructure is first talk about multi-purpose grants. So things that could be that are not specific necessarily to any one type of thing, any one type of infrastructure or even infrastructure versus housing, but are more general in nature. And then we'll talk about specific grants for infrastructure. Then we'll talk about other financing mechanisms, basically for infrastructure. So this first one is on multi-purpose grants, and in it we'll talk about the NAHASDA block grant, using that, the competitive block grant, basically competitive, not NAHASDA block grant, the ICDBG or the Indian Community Development Block Grant, and then the ICDBG Imminent Threat Grant in this context. And this is just another slide, mostly for a plug for the Housing Development Handbook, which, as Bill noted, is real helpful because it kind of goes through the different areas of funding and has both information about the funding sources and some issues to think about as a best practice to think about when you're thinking about going after that funding. So this is the same list of grants I talked about before, so we can kind of go on beyond it. But the first one we'll talk about is the NAHASDA block grant. And the NAHASDA Indian Housing Block Grant, as you probably are all aware, even the folks that are newer to housing, I'm thinking you're probably aware that that's a primary source of funding for your housing authority. And it's primarily focused on housing finance, and even probably more so on, it typically is used a lot of times by housing authorities to finance or pay for their operational costs. It can also be used, for housing financing, but it can also be used for beyond that for infrastructure financing. So it's important to think about in this context too. It's also important to talk about its limitations, so I'll do that as well. And then for the ICDBG grants, those are really focused on being truly multi-purpose, where they can be used for a number of infrastructure uses. In fact, the housing aspect of it is somewhat more limited. It's really for housing rehab as opposed to new housing, at least in general. It has a lot of restrictions on new housing use, but it's real important for infrastructure as well. So we'll be talking about both those grants as well as the competitive Indian Housing Block Grant. So the normal kind of set block grant you guys receive, and I think you're probably all aware, you get a certain amount that's set based on formulas, but it can be used for a wide variety of things. It can be used for affordable housing development, including buying property. It can also be used for development and rehabilitation of utilities. So for the utility lines and things coming through the reservation, that can be used for that, or for housing. It can be used just generally for infrastructure, necessary infrastructure and utility services. It can also be used for things like converting buildings for demolition, for financing, generally in administration planning costs. And it can be also used for creating projects for energy efficiency projects in your homes and buildings, for mold remediation and other related activities. So it really covers almost any kind of activity that relates to housing, especially if it's relating to housing for low to moderate income members. So it's a very important funding source that can have a multitude of uses. And so that one of the key advantages is that it's, as you're probably aware, it's very flexible in its use. You can kind of move money around. You have an Indian housing plan that can be modified over time. And it's not competitive, so it's money you have for sure. The biggest issue is just how do you pay for your operational costs, and do you need most of your funding from NAHASDA, or at least a large percentage of it, for your operational costs? So because of that, it's both important, it's a really important injection source for meeting cost share under other grants, and perhaps, you know, like one of the members of one of the attendees noted that they were saving their NAHASDA money and put it, you know, after a number of years into a project, which can be great for that too, to pay for a lot of a project then. But I think you're always going to be thinking about how do we leverage that money, and how do we use both, how do we leverage the NAHASDA money, and then how do we use the NAHASDA money as leveraging, or, you know, kind of cost share on other grants, so we can make the pie as big as possible and get as much done as possible. So there's a variety of, you know, grants that can help do that, and programs help do that. And so that's what we're going to be talking about for basically the remainder of the program. That, you know, you can't use your NAHASDA money for everything, all the things for infrastructure, housing, and for energy projects that you need to, that you want or need to accomplish. But fortunately, there's other programs to take advantage of to fill that in, and to, you know, leverage the NAHASDA money, and then allow the NAHASDA money to leverage these programs. So the IHBG competitive program is relatively new, or, you know, especially in terms of the long term, very new. And it's meant to supplement NAHASDA, the NAHASDA block grant that's, you know, formula driven. It was introduced in 2018, 2019 as part of the Appropriation Acts at that time. And it's really based on a needs study that was done back in 2017, showing basically a huge shortage of housing units in any country, 68,000 units short. And so for the last few years, there's been included in the appropriations significant money for this grant. It was $150 million most recently. And it's the bad news on it, I guess, is that it's competitive. So you're going to be, and it's really, I think, becoming more and more. It is highly competitive. I guess I don't know. Actually, I don't know if it's gotten a lot worse or not in terms of competition. But we'll talk about it a little bit. There's a lot of money available. The grants can be very large. So because of that, there's a lot of competition for it, and it's, you know, incredibly valuable for whatever tribe receives it, whatever housing authority receives the grant. And it's similar to ICDBG grants, which have been around a lot longer, and that, like, a lot of tribes have more, tribes and tribal housing authorities have more experience with, in that it considers both the need for the project and the administrative capacity of the project. And you know, they're giving priority to projects that will spur construction and rehabilitation. So, but really, they want to know that, just like for the ICDBG grant, they want to know that you've had successful projects in the past, that this is likely to be a successful project, and the project makes sense. So, so it's a very similar application to the ICDBG application. They're both obviously HUD, so that's another reason why too, I think. So they have a points, you know, schedule on it. This is for the most recent notice of funding that was put out on July 26th of last year. And it has, you know, a variety of scoring factors. The scoring factors, if you've done ICBDG but haven't done this yet, you'll see that's fairly similar. A fair amount about the capacity of the applicant, and a lot of that relates to who's on your team to get the project done, and does the team have recent, relevant, and successful experience. You know, recent, I think it's typically 5 years. The last 5 years, what it is that's been done, what's been successful. What they're trying to look at there, I think, is, you know, will this project likely be successful because we have a good team to get it done, and folks that know how to get this kind of stuff done. In terms of relevancy on the prior project, I don't think they have to be the same project, but have you done other stuff that shows that you can get this stuff done? There's also points based on the need and extent of the problem. Some of that you can't control because it's based on, you know, factors about the tribe, stuff like that. But making sure it's clear what you're doing and why is very helpful. They also have a lot of points for soundness of approach. They want to make sure that there's a clear approach to make sure the project gets done. Again, I think this is typical for a lot of the grant programs. They want to know that if they give out these large amounts of money, that the project should be able to be successfully completed. There obviously things can get up in the way as the projects go along. The grant agencies understand that, but they want to know there's a good chance of success in the projects that they award, the projects they award funds to. There's also some points for leveraging. That gets into, again, this idea of having some money available that's not from this grant to be able to finish out the project. And that's where it's helpful to have, talking to your tribe about, have we addressed right away? Could we use that for funding, or do we have other funding sources? We saved enough of our NAHASDA money, we put some money towards that this way, or do we have other funds that we can put into these projects? And one thing that could be valuable to think about here, especially this could be used. The reason we're addressing it here is because it can be used for infrastructure. So if you have any funds from, let's say, the Department of Commerce in your state, or other funds that would help with the infrastructure costs to help leverage the funds, that'd be great. Also, if you have right-of-way funding to help pay for leveraging, that would be great. Also, if you just have reserved some of your NAHASDA money to help pay for this, that can be great too. So we want to make sure, one thing to note on these points is that this is a very competitive grant, so you want to make sure you're getting all the points you can. You don't want to give up points, so it's important to make sure you do get some leveraging, enough leveraging to get the 5 points, and that you've addressed all these issues for points. So it's not like, because it's 5 points compared to the whole, you're okay to let that go. I think that there's a real issue that unless you can be absolutely perfect in every other area, you're probably going to be disadvantaged if you can't beat the 5% leveraging. They also want to see that you have just like the Soundest approach, they have a comprehensive approach, and you have good coordination with other entities. There's also preference points for climate change, which I think can include both, I believe at least both stuff in your project that would make the project basically greener, more sustainable from that point of view, and then also thinking about climate change impacts. So you want to be thinking about that as well as you're putting together your application. And there's also points for a province zone. The problem with that is that it's great if you're one of the reservations listed below there, but if you're not, you can't get those 2 points, which just means that it's another reason to try to really make sure you do well on the points you can't get. I guess fortunately, in some ways, it's not like a third of the tribes have it, and the remaining 2/3 are at a big disadvantage. There's only 4 tribes that have it. Oops. Sorry. So the actual funding that's going out for this part of the award, this season of the awards, basically this year of the awards, is about $130 million almost. But the thing to point out here is that they're not expecting that many awards, given the large amount of money that's going out. So it's 25 awards that are expected under the NOFO. And that's really because the maximum grant amount is high. It's $7.5 million, which means that it's going to make a real difference on your reservation. It can make a real difference for either infrastructure or housing on the reservation. And so I think it's one of the things if you have the resources to go after, you really almost have to go after it because it's so valuable. But the one thing you point out is that it is a very competitive application, just because of the limited number of awards that are expected to be made. The deadline has already passed, and so, but the same program is now become part of the competitive IHBG has become part of the landscape now. It's an important grant, important multi-purpose grant to be aware of and to be ready to pursue every year, or at least have plans to pursue every year, I'd say. So the second kind of major competitive multi-purpose grant is the ICDBG, or the Indian Community Development Block Grant. And this one, it's, the objective of the grant is to develop viable Indian and Alaska Native communities, including decent housing, a suitable environment, and economic opportunities, really focused on people that are low and moderate income, which means 80%, less than 80% of the area median income. So it's a really wide scope of a grant. Its biggest issue is that it's not for new housing, but the new housing is covered, as well under the Indian Housing Block Grant, the competitive Indian Housing Block Grant. So, but this one is even more focused on non-housing stuff, so infrastructure. Since it's pretty limited, it's used for housing. Housing again is really for housing rehab alone. So the uses of the land, so if you need to get to buy real property for your projects, it can be used for that. So that's even kind of pre-infrastructure. It can be used for a wide variety of infrastructure projects, including streets, roads, water and sewer projects. It can also be used for public facilities, things like shelters for the homeless, convalescent homes, clinics, nursing homes, temporary housing, that kind of stuff. So it really has a wide variety of purposes. It's in fact, it's one of those grants that really it makes sense to develop a team that is ready to go each year on these, especially to the extent the tribe will authorize the housing authority to go after these funds. The one issue for it is that there could be other housing departments or entities that also, let's say, they're the ones that wants to build a clinic. They may be coming in and actually competing against you to be able to submit the tribe's application basically for this grant. But in some housing authorities we worked with, the tribe will say, for them, the tribe will say the housing authority gets it every year, and then every year besides that, some tribal department or other tribal entity can go pursue the grant. So it's good to make sure that you're in line as well as the housing authority to be, if you're not now, to be in line soon to be able to, get access to this grant as much as you can, basically. But there's definitely tribes we work with and housing authorities work with that the housing authority is allowed to go after it every year, and they have a really good application, basically format down now. And they keep successful projects working along the way. So they have recent, relevant, and successful projects, and they can just keep on being in good stead to get the grant in better position than other tribes that way. And then other eligible uses of the ICBG include economic development activities such as acquisition, construction, reconstruction, rehabbing, or installation of commercial and industrial buildings, structures, and other real estate property, equipment, and improvements. So basically, it can also be used for economic development, as long as that economic development is targeted at low and moderate income folks, providing jobs for them, things like that. It can also be used for planning activities. So if you're not yet ready, if you're looking at a large development and you are actually at the planning stage, you could also, use this, go after the grant to get funding to help plan your project, to develop comprehensive plans, community development plans, and plans like that for housing and economic development. So it can also be used for planning. Most of the folks we've worked with in the past, most housing authorities have, used it for either infrastructure or some sort of housing rehab, but it can be used for a really wide variety of purposes. So, as I mentioned before, the big issue on this, or one of the bigger issues, is that all the money has to be used for projects that support low and moderate income persons. And how that's applied depends on the type of the project. So if a project benefits all the folks in an area, then at least 51% of the residents in that area need to be low and moderate income people. So if it's, so if you're putting in, let's say, a community center and it serves everybody on the reservation, then 51% of the folks on the reservation would be low and moderate income. If the project benefits only a limited clientele, let's say it's something related to the elders on the reservation, then 51% of those elders would have to be low to moderate income people. And then if it's a housing development, it has to be occupied. If there's single family homes, then every home would have to be occupied by low to moderate income persons or families. And then if it's multifamily housing, let's say like an apartment building, then at least 51% of the people that would occupy that house, let's say that apartment, would have to be low to moderate income folks, LMI folks. And if it's a job creating situation, so if it's one of those, it's an economic development project where you're going to build, let's say, a factory or something like that, or other kind of commercial or industrial building, then 51% of the jobs to be created by that project need to be designated for low to moderate income folks. So you have to be thinking about that in terms of how your project works before you put together your application to make sure it's going to fall in the right category to get the funding. And then this slide just goes over how the money's divided between the different ONAP area offices. So it's important to note that you're really competing against others in your ONAP area office. So if you're in, let's say, the Northern Plains, there's almost $12 million available for all the Northern Plains tribes. If you're in the Southwest, which has some of the larger population tribes, then there's actually more money available. It's $33 or $34 million approximately available. Again, you're competing against those tribes, so you have to just be, it's just something to be aware of, I guess, mostly, which makes it so that you have to basically do better on your application than the others in your ONAP area office, or at least well enough to get the funding. So this just shows the grant ceiling amounts for the different regions, which have gone up. So it's in the past, when we first started working with, well, I guess not first started working, but in the past when we worked on, especially this grant can also be used for things like solar for homes and stuff like that. We had some tribes that were interested in doing that, and we helped them with that. And back when that was done, it was only probably 6 years ago or so, 5 years ago, but the grants were much smaller. They were at that time for the Eastern Woodlands area, at least, were being $600,000. And a lot of the other areas were about that level, except for the Southwest, where there's, again, bigger tribes. But now they've all been raised to the $2 million ceiling, and for the bigger tribes in the Southwest, they've gone up even higher. So, so that does two things. It makes the grant more valuable. Obviously, you can really pay for a good chunk of a project. Obviously, things have gotten more expensive too. I think a fair amount of the comments and questions, especially in the chat, have been trying to make projects work with inflation. One good thing is that these grants have gone up in amounts. A fair amount of them gone up a lot. Both these grants are worth a lot of money, both the ICDBG and the competitive IHBG. The problem is, though, that even though the funding has gone up significantly for these grants, because of the higher ceilings, they're just as or more competitive than they've ever been. So I think it gets into really making sure you have a good development team and a good plan of action for what projects you're pursuing, why they meet the criteria for the grant, and how you can explain that, and how you can. And to a certain extent, it is a situation now where the better you're able to operate and make projects work, the more likely to get funds too. So you want to make sure your projects that are going forward are successful, so you can explain that in your upcoming grant applications and do better. So fortunately, there's a lot of money out there. Unfortunately, it's still a very competitive environment for that money, and you want to make sure you're on top of things that way. So there's similar scoring for the ICDBG as there is for the competitive Indian Housing Block Grant. So again, capacity of the applicant they're looking at strongly, which again gets into who's on your team to develop the project, what's their recent relevant and successful experience on projects, things like that. You also get, if you get into the need and extent of the problem, and they also now are looking for a connection to climate change again. So they're looking for, I think, how the project helps address climate change concerns, how it factors in that. So you want to, and I think a lot of it gets into, how does this project make us more resilient in terms of climate impacts, and or how does it help mitigate climate issues by being more sustainable in terms of lower energy usage, clean energy usage, stuff like that. So you want to be thinking about that in your projects. You probably, in general, want to think about your projects for a variety of reasons. One is to make sure they're resilient. Two is to reduce the energy costs for any project going forward. And then three is that it's kind of an important issue probably in a lot of grants now. It's important in terms of, I think more, even with we'll get the new market tax credits later, that they're looking for, the various folks that are providing the money are also trying to make themselves look good on climate change related issues now, I think more so than the past. And so the more you're thinking about those issues as you're going forward, the better off you'll be for funding sources, and for making your buildings or your infrastructure more resilient and less costly from an operational point of view too. So it does make sense to be thinking about that too, I think. They're also looking, just like the Indian Housing Block Grant, the soundness of the approach. They want to make sure that you have a clear plan of action of what you're going to do, clear timeline, what will be done, things like that. They again have the leveraging resources, which again gets into that issue of how we're going to get the cost share, or they call it leveraging here, but it's really just cost share. How are we getting the cost share covered? The good thing is that you can use the HUD grants. The good thing about it, you can use there's not like a non-federal issue on that, so you can use other federal sources of funds. But again, it's important to be thinking about how do we get to at least, I think it's 25% leveraging to make sure we're getting the full 6 points. Because again, as a competitive grant, you want to make sure you get all the points you can. They also, similarly to the IHBG, have a comprehensiveness and coordination to your approach. They want to check and make sure that you're got to be covered and then you're coordinating with others in terms of building the project. And then, again, fortunately or unfortunately, there's preference points for Promise Zone, which helps certain tribes. And then this just shows, for the latest round, when it came out, the NOFA funding announcement came out in July as well, July 29th. And again, there's more money than the past. I think in the past it was closer to about 60 million. Now it's up to 92 million or so. But again, the award amounts have increased so that it's still very competitive. In fact, it may be becoming more competitive as it goes forward now with these higher amounts of money. People are probably saying it's really important for us to go after the $2 million. So I think it shows again the importance of having your team ready and having a clear plan of what you're doing and make sure your projects over time do well, because that will help you do well in the grants going forward. That was the October 24th was the deadline, and they expect to make 80 awards under this NOFA. So, or NOFO, they call it. Or I think it's actually NOFA. But regardless, I think it also makes sense for you now, whether you've applied for these 2 grants in the past or not, it also makes sense for you to be on top of the grants that will come out next year again, or this year, basically later this year, for both programs, because they are really critical to funding both infrastructure and housing and energy related projects, things like that. So it's really 2 really important tools in your toolkit to be aware of. The last thing I just wanted to talk through briefly is the imminent threat grant, the ICBG imminent threat grant. And it's, really, this is more one to meet, really significant issues that affected, that's a unique problem on the reservation that's unusual and that affects the entire community. So it has to be something that really came up. It's typically unexpected problem on the reservation or with your housing that affects basically all the housing. So if there was a fire that came through that affects everybody, or a major outage, let's say electricity that affected everybody, that led to a lot of flooding, that kind of stuff in homes. It was cold and it got warm again, things like that. So if a big problem comes up, it makes sense to be in contact kind of right away with HUD about it, and to confirm whether the project would meet what they would consider to be eligible for this imminent threat grant. And then 2, it's important to know that there's a fair amount of money here, but it's not, it's not a ton, but it's not really so much competitive as it's first come, first serve. So if you have a problem on your reservation that occurs, it's pretty reservation wide, it's affecting your housing, things like that, I would basically immediately go to your HUD contact at the ONAP office and start talking about this and say, does this sound like something that we could apply for imminent threat grant? And then just to do it right away, so you're have as much as you can be first in line to get the funding for that project, or that kind of cleanup project, basically. So now we're at the Multipurpose Loans. And sorry, Bill, and I'm gonna sheet open up right now. Is this Bill?
It'll be me, John.
Okay, sorry, Mark.
That's okay.
Fantastic. I think we can cover them well. So why don't we just get started on this? We'll see how long it takes. We can obviously stop midstream, but why don't we plan on stopping somewhere around noon central, just so we're kind of good on the lunchtime too. But why should we start, Mark, and we'll see where we should kind of stop for now.
Sounds good.
There you go, Mark.
Okay, thanks. So next we'll talk about multi-purpose loans for housing infrastructure. And the multi-purpose loans available include Title VI loans, Rural Development Community Facilities Program, and tax-exempt bonds. So first is the Title VI Guarantee Program. And NAHASDA Title VI authorizes HUD to guarantee obligations issued by tribes or the Tribal Housing Authority with tribal approval to finance affordable housing activities. The proceeds from the loans or other obligations can be used for modernization or rehabilitation of existing 1937 Act housing, development of new affordable housing, and model housing activity. The guarantee covers 95% of the outstanding principal balance and the accrued interest due on the loan. The max Title VI commitment is 5 times the need portion of the annual Indian Housing Block Grant allocation. The tribe or the Tribal Housing Authority has to pledge its NAHASDA block grant to assure repayment of the loan. And the tribe or the TDHE has to demonstrate experience in complex financial transactions, that they've attained tribal approval that authorizes the obligation, and demonstrate an ability to repay the obligation without impairing its use of NAHASDA block grant funds. Next is the Community Facilities Program, which is a combined grant loan program administered by the Rural Housing Service of Rural Development. And the program funds here can be used for essential community facilities. And essential community facilities includes a pretty broad array of facilities, which we'll see in the next slide here as some examples: fire, rescue, public safety, health services, community social cultural services, distribution systems, transportation facilities, as well as the acquisition of land needed for the facility, the professional fees associated with that, and the purchase of equipment that's required for the facility's operation. The grant assistance is limited to the minimum amount sufficient to provide for the facility's operation and maintenance, provides for reasonable reserves, and for debt repayment. The grants can be up to 75% of the cost of developing the essential community facilities, and smaller communities with low median household income are potentially eligible for projects with a higher proportion of the grant funds. The loan component of the program, which can also be a guarantee of a third-party loan, has interest rates determined by the median household income of the service area and the population of the community. The terms can't be longer than useful life of the facility, the applicant's authority, or a max of 40 years, whichever is less. And the tax-exempt notes or bonds can be used to secure the loans, but can't be used to guarantee the loans. The guaranteed loan program provides loan guarantees to eligible lenders for essential community facilities in rural areas. The loan guarantee percentage is published annually in the Federal Register in a notice. And the CF loan guarantees approved in FY21 got an 80% guarantee, and the maximum amount of the guaranteed loan is $100 million. Interest rates are negotiated between the lender and the borrower, and can be fixed or variable, and variable meaning they can change within a year. But if it is a variable interest rate, it can't be adjusted more often than quarterly. And the tax exempt financing can't be guaranteed by this program. So last is the tax exempt bonds, and tribes, like states and municipal governments, have the ability to issue an unlimited amount of tax exempt bonds in order to finance projects relating to essential government functions like schools, roads, water systems. And the tribal subdivisions, including the housing authorities, can apply to the IRS for the same authority, and many have actually done so as well. So with bonds, because bondholders don't pay federal income tax on the interest they earn on tax exempt bonds, they get or willing to accept a lower interest rate. Bonds can also be repaid over a longer period of time than a bank loan. With negotiated purchase of a bond, the potential buyers are local banks or the Rural Development Office of USDA. For larger bond issues, there will usually be a security underwriter who can arrange for the public sale of bonds. And because the bonds represent a loan to the tribe's creditworthiness will really affect the ability to sell bonds, what interest rate will be, and kind of the appetite of buyers. Tribes can issue tax exempt bonds only, however, if substantially all, which is at least 90% of the proceeds, are used for those essential government functions that are customarily provided by state or local governments. And these bonds can be used to finance facilities owned and operated by the tribal government for the general benefit of the tribal members. Eligible projects include, like we said earlier, housing, schools, healthcare facilities, water, sewer, police and fire, convention halls, administration buildings, drug and alcohol treatment centers, and others as well. I think the last thing to note here is just that the issuance of bonds is a pretty complex process and requires a significant investment of both time and money. So any savings that a tribe can realize over the long term should really be weighed against the costs of issuing the bond at the outset. So that wraps up that section. Is this good time to take a break here, John?
Yeah, it might be a good time to take a break now. Maybe we should, if it's okay with folks, why don't we just come back at 10 to the hour? As a new ARPA tax credit program is relatively complex. I think it's helpful to know about. So why don't we take our time going through that and the stuff that follows from it? So why don't we'll just all come back at 10 before the hour and continue on with the program. Thank you.
Sounds
All right,
good.
guys. Thank you very much.
And I thought I'd just recap a little bit what we talked about so far on infrastructure, just so we're on the same page on where we've gone so far and where we're going. As you probably recall, I spoke, I guess, first about infrastructure stuff. I talked about the kind of general grant programs that are available, and for that, and that included the HOSTA block grant, which obviously is great because it's non-competitive, but it's not so good because it's limited. And if we can use that just for your operational expenses and perhaps for you have some of it available for leveraging, that can be really helpful. And that can be helpful for the two grants we talked about in more detail. The HUD IHBG competitive, which is, both these have come out already this year, but it'll be out again, I think, or it came out already last year, it'll be out again this year. The IHBG competitive is worth up to $7.5 million. So it's a lot of money. It can be used for infrastructure or housing. It can be really valuable, but it's very competitive. So it's good to be on top of that one for both reasons, I guess. And then the ICDBG, which is also competitive, now worth a fair amount of money, at least $2 million. And, like the IHBG competitive requires some leveraging. So the HOSTA other funds can be great for that. And can be used for a wide variety of infrastructure as well as some housing purposes. So that's all very valuable. Then we went into the loans, and Mark went over that, in a fair amount of detail, but just to kind of highlight some key points from that. Again, the Title VI loans are loans where you use your HOSTA money as collateral. Doesn't mean you need to lock up your HOSTA money and not use it. It just is a backup to the loan. So if you don't pay the loan back, then the HOSTA money can be gone after. So you definitely want to pay back the loans, but it can be used as a source to help fill in the gaps, especially for infrastructure where maybe some infrastructure may be more difficult to find funding for than other things like, housing. You have the IHBG competitive, plus you have the tax credits we'll talk about later on, which can be really helpful for housing, but you can oftentimes have infrastructure costs that you need to cover. And then we also talked about the Rural Development Community Facilities Program, that's USDA. It's very important. I think this is one of the important agencies to be connected with. I think for one thing, they're also very helpful in helping you become aware of and connected to other sources of funding besides their own. We put it here under loans, even though, as Mark noted, it includes the grant component, but it's difficult to get a lot of grant money out of it. There's more loan money available through it, but it's an important agency and program to be aware of, and USDA is involved in a lot of other housing type stuff too, so it's just very good to be connected to them. And then on the tax exempt bonds, that's only really if you're doing a major project, you have significant debt you'll have to take on. The advantage of it obviously is that it's tax exempt, so the lenders will give you money at a cheaper interest cost, so that's great. The issue is that it takes a fair amount of work to do those kinds of bonds, fair amount of legal support and other support. So you'd really want to consider that if you're having putting in major projects and you're going to have significant kind of shortfalls from the grants and tax credits, and then you might want to do that as well. But then, so that takes us to current, and now I'm going to get through this stuff here, pick up with new market tax credits. And it's another program. It is complex as well. It can be very valuable though for certain projects, I guess I'd say. So it's mostly valuable, I think, if you have a project that costs a lot of money, and it has a gap. So you have, let's say you have money from various grants and other sources, but you still have a gap. It can be helpful for that way because for that setting, because it's not a loan, right? I'll go into in detail what it really is. It has a loan kind of component to it, but it can be ultimately free equity money, free money coming into your project. So at probably about 15 to 20% of the cost of the project. So it's important to know about it for that reason. With that background, I'll go through how it works. Again, it's relatively complex, but can be worth it on bigger projects where you have a gap in funding. So the new market tax credit program was set up to encourage economic development and job creation in low-income communities by basically attracting private money, private investment into those areas, into those projects. And it's a new market. It's called a tax credit because it is a tax credit. So, but it's a limited allocated tax credit. It's like some ways like the low-income housing tax credits that way. There's only so many of those available, and there's only so many of these available, these new market tax credits. They're allocated by Treasury to what are called Certified Community Development Entities, or CDEs. And what happens basically is that the CDEs that have the tax credits to dole out to investors, the investors bring their money in return they get the tax benefits that are spread out over a 7-year period of time. And then, the CDEs, basically through an LLC that includes the investor, then provides the capital to the qualifying project. And new market tax credit allocations are done out of the CDFI fund, which is Treasury, and they allocate new market tax credits annually under what's a really highly competitive application process. So we've worked with CDEs before where they want to have sample projects in their application to explain, to show basically to CDFI that they'll use the money in a way that that's good and that should be supported. So sometimes you may be aware of this too. If your tribe is connected to any CDE, they may actually, you want to put your project as a potential project in their application, which helps you then be in good shape to get the new market tax credits for your project. But regardless, it's a very competitive process. And you know, in the early years, the money was more focused on urban areas, not in rural areas. Now the law has been changed to ensure that these non-metropolitan counties, they call them, receive their fair share, basically the allocation, which is obviously important to tribes because much of any country is in rural areas. So the good news is that the program has been modified somewhat so that there should be a relatively good access to new market tax credits for rural areas, including tribal areas. And so, you know, what is a CDE? This community development entity, they're basically organizations that are set up with a primary mission of serving or providing investment capital for low-income communities and low-income persons. They have to maintain accountability to the residents of the low-income communities by having representation on their governing or advisory boards of those residents. And then they're certified by the Secretary of Treasury, you know, to be able to be a CDE. So it's only a select group of folks that can get the tax credits, and then it's very competitive among those folks as to who gets the tax credits. Is the bottom line. So then, you know, who is an eligible borrower of the new market tax credit funds? And again, you're a borrower, but you're also, as I get to later on, able to potentially get loans forgiven, and that becomes then like free equity for the project. But I'll talk about that in a little bit. So the eligible borrower is limited to what's called a Qualic B, or a qualified active low income community business. And in order to do that, you have to have 50% of your income from active conduct of a qualified business within a low income community, and have a substantial portion of your property and employee activity within a low income community. So what oftentimes happens with the tribe is that they might set up, or a tribal entity would set up a separate LLC that is focused on work in the low-income community. It's conducting work as a business that way. So for a project, you might have the project owned by that entity. It doesn't have to be a taxable entity because the tax credits go to the investor, so that's good. But then you know, again, it's basically a CDE. Going through the acronyms again, the CDE can form a partnership with an investor, and then provide the investment into the Qualic B, and then in return, the investor gets the new market tax credits. So the question is, what's a low-income community? And these are basically, you might have heard about them. There's new market tax credit census tracts that are out there. They have to have at least a 20% poverty rate, or a median income of in a non-metropolitan area that does not exceed 80% of the statewide median family income, or be in a specialized target area. So, but the good thing to know is that if you go to if you search for new market tax credit mapping, and you go on the web, you'll see various maps that will show different parts of the United States, and the census tracts within those, and will show which ones qualify as new market tax credit eligible areas. So if your reservation, or wherever you want to build your project, is within one of these, then at least your project could qualify for new market tax credits. And then if that's the case, and you have a project where it's a big project, it's expensive, you're putting a lot of work into it anyways, and you're going to have a gap in funding, then you might want to reach out to potentially relevant CDEs. You can also search the internet for the list of CDEs and what their funds are available, and you can start to see who should we start talking to, who should we start contacting. And it's really kind of they want you, perhaps not as much as you want them, but they're looking for projects too. They're looking for good projects. These CDEs, they want to have projects that will look good when they report back to the federal government in terms of what they were able to do with the tax credit money. So if you have a project that really does a lot of good, and especially if it meets the criteria that the CDE put in, you'll see it. You can search for that too and talk to them about it. What are the primary goals of the CDE? Because those are what they reflect, that they provide to the federal government when they're seeking their allocation. So if they're looking at creating jobs or looking at other metrics they're trying to achieve, you'd want to make sure that you're kind of thinking about how does my project relate to that, and then talk to them about it and say, hey, we got a good project for you because it does this. So what can you use what kind of projects are the new market tax credits eligible for? They can be used in the financing of new construction or rehabilitation of any trade or business. And that's pretty broadly defined. It can include any kind of manufacturing or real estate development. For example, development of property for rental to third parties, any retail, healthcare, government facilities, schools, daycares, et cetera. So it can be used on government facilities as well. It can be used, for example, we've been kind of dividing this up, as you know, in terms of infrastructure. We're thinking of infrastructure broadly because if anything is not housing, we consider infrastructure for this program because we're trying to figure out, how to finance these various things that a housing authority might be involved in. So if you're building some kind of a either like a daycare center as a part of your housing or any kind of community facility is related to your housing, these are all uses that this could be, used for, that the new market tax credit is going to be eligible for. But a wide variety of purposes. The one thing it can't qualify for is probably the biggest thing it probably can't qualify for, and is for things that they consider residential rental property. But kind of the good news about this is that they define residential rental property to mean any building or structure if 80% or more of the gross rental income from such building or structure for the taxable year is rental income from dwelling units. So if you have a mixed use development at all you're thinking about, that could potentially qualify as long as the rents aren't too high. For the rents are too high for the residential units compared to the non-residential units. So this is one of those things where, again, you probably won't pursue it unless you have a lot of projects a lot of large, scale expensive projects you're looking at doing. But if you are, and you're going to naturally probably then have some gaps, this is at least something to at least be aware of and thinking about, because it can be very helpful. I'm actually on the board of like an ecology center now that's building a new center, and they're in a low-income area, and they just got their, they're doing their deal now with the CDE. Since they have 80% funding for the project, the CDE will then pay for the rest. To the new market tax credits, they'll get the free equity that will eventually pay for the rest of the project. So it's real helpful for them in that, for example. So, why, what are the benefits of these new market tax credits? Why do these investors want to get involved in these projects? Investors want to get involved because there's credits equal to ultimately 39% of the dollars they invest. So they're spread over 7 years, and they're 5% for years 1 to 3 and 6% for years 4 to 7. So if you do the math and add together, you get to 39 cents, I think. Or you get 38 cents. So you get 24% plus 15% basically. But then it varies a little bit on what the present value of that amount is. Present value is the amount it's worth today for those future dollars, basically. And it's worth like 20, they say it's generally worth like 25 to 28 cents, depending upon the discount rate that's used. It's probably worth closer to 25 cents now because the interest rates have gotten higher, and therefore the discount rate has gone up. But, and that really allows for the investor to be willing to make either on a small loan, a lower interest loans, or in a bigger project to basically make free equity available. And then that usually yields, 10 to probably somewhere closer to 20% free equity for a project. So again, it's not going to pay for the full project, but it can help pay for these gaps, and it can help avoid traditional lending, getting loans, because the good news is that if it's the free equity, if you're big enough project and you get free equity, you don't have to pay it back. So that's the basic idea of it. And so it basically, you know, reduces the amount of project debt service and allows for some more hard debt to be in the project, but it basically allows to make uneconomic projects possible. In fact, that's what the CDs will typically be looking for. Besides the particular goals they have from the project that they're trying to match up to what they told the federal government that they would achieve through the project, they're also looking to be able to explain to the feds how this project would have had difficulty, would have been uneconomic, would have had problems going forward, but for this new market tax credit money coming in, and now it makes the project work. That way the feds can kind of take credit for the project too, and so can the CDE. So the biggest downside of new market tax credits, I think, is their complexity, because you have to negotiate deals to make them work out. I mean, on the other hand, a lot of these projects are complex, as you know, for the funding. So if you go for a, let's say a IHBG competitive grant, you're putting a lot of time and effort into that, and you have to have the grant compliance work anyway. So it just adds more complexity, though, to have this as another element of your projects. Typically, new market tax credits are used on projects that are 5 million or above in size. The bigger, it takes the same amount of work to do the transactions that basically are involved in the new market tax credits. So no matter the size, so it works better for the bigger project. They can do a simple loan structure where there's just a reduced rate loan for down to about $1 million project size. But if you want to have the new market tax credits provide actual free equity to the project, you're going to need basically a bigger project, probably about $5 million or more. And so the way it works is that there's a lender, which is either, the smaller ones, it's a low interest loan, or in the bigger ones, the loan that kind of disappears and becomes free equity. It's done by the folks that bring the money are basically a limited liability company that's set up specifically for the project at hand. So let's say you're building a community center or something like that, and you get new market tax credits for it. The limited liability company, which will be made up of the lender, which is the investor of 99, who's typically a 99.9% owner, because they're the ones that get the tax credits and they're taxable entities, and they're like 0.1% by the CDE because they're a nonprofit, and bring the tax credit allocation to the project. That LLC will then make a loan to the Qualic B for the project, and then it's either, and then typically on the free equity for the bigger deals, there's typically a market rate loan, and then a low interest or forgivable loan for the strike. But this point actually covers both kinds. So there'll either be, if a simple loan, there might be for a smaller project, might be a component that's a market rate. There might be a very low interest component. For the bigger projects, it'd be like a market rate loan, to the extent one's needed, and then like a forgivable loan. They can see the free equity. And then the lender typically requires a guarantee from the Qualic B's owner or related party, especially if you set up a special purpose entity to own the, let's say, community center or whatever you build, and it might be a project that includes like a community center and then a fair amount of infrastructure that can be used, helps your infrastructure for your housing too. Let's say the Qualic B, if it's, a special purpose entity, they'll then require that the housing authority, as the owner of the Qualic B, or the tribe as the owner of the Qualic B, provide a guarantee so that there's like assurances that any, especially true loans, will be paid back. And I think that's it. Yeah. So that's another kind of important thing to at least be aware of if you're doing large scale projects, especially for non-housing itself, but it could even be for housing if you're, again, at least 20% of the revenue from the building would come from non-housing purposes. It can be very valuable, but it's another tool in your toolbox. Now I'll go to Bill, who's going to talk about water related programs.
Thanks, John. So this is an area that I do have comfort. As alluded to in the first intro, I used to work for the Wisconsin Department of Natural Resources, which oversees some of the programs listed here, but many of them are specific to tribes, and you should be aware of the pros and cons of these programs, and aware of what type of projects they cover, because they do have different limitations, and you might be able to fit one into your overall project plan and development plan. So, sorry. There we go. Yeah. So the 5 main programs I'm going to cover are as listed here: the USDA Rural Utility Service Water and Environmental Program, the EPA's Clean or Drinking Water Grant Program, and the EPA Clean Water Set Aside for Tribes, the Department of Defense Water Resource Grants, and which may be lesser used, but maybe depending on where you're located, that might apply. And the Department of Health and Human Services Indian Health Service sanitation grants. So we'll start off with the USDA program for rural utility service, for us, water environmental program. That's covered in page 34 of the handbook if you're following along. But as far as what does this program cover, it covers funds to be used for water and waste disposal facilities. That includes water lines, pumping stations, wells, storage tanks, and sewage treatment facilities. So these funds are limited, and eligible projects do compete nationally. So we don't have specific breakouts by region. And you want to keep in mind that these projects are funded on a first come, first served basis once complete applications are received and approved. So those annual national program funds are available until they're not. So there's a defined window when that can be applied. This program provides grants and below market loans to public bodies, including tribes, as well as nonprofit corporations and associations in areas with a population of less than 10,000. So it is not just limited to tribes, but given the population eligibility criteria, tribes are often score high on these sort of grant programs. So I do want to cover some of the program limitations for this, and up to 75% of project costs may be covered by a grant where the median income in the service area is below either 80% of the state non-metropolitan median income or below the federal poverty line. That's a limitation. Where the income in the service area is between 80 and 100% of AMI, the maximum grant is only 45% of project costs. So understanding your baseline is critical for this program and whether it's a good fit. Grants are not available where the median income in the service area exceeds 100% of the state non-metropolitan median income. And where funds are required to alleviate health risks for tribes, there can be 100% project costs available funding, and that can be up to $1 million per project. So these can be really big, and depending on the need and sort of the underlying factors that you can demonstrate that you're a good candidate for this, that will certainly tell you whether or not this is a good fit for your project. So I do want to talk about the loan aspect of this. We did mention that they offer loans in addition to grants. Loan rates depend on income levels of the tenant population served, and those are published quarterly. So those are available on their website. And RUS normally requires that the loan to a tribe or a TDHE be structured as a bond. That's their preference. Their preference is for 3 reasons we list here. Faith and credit of the borrower when the debt is evidenced by a bond, the pledges of taxes or assessment, or pledges of facility revenue are 3 ways to secure that security. So when it's customary financial practice in the state, some liens will be taken on the borrower's interest in land, easements, right-of-way, water rights, water sale contracts, sewage treatment contracts, and other similar property rights And that can include leasehold interests that are used or to be used in connection with the facility. The rust bond requirements are not as onerous as the requirements for issuance of most municipal bonds, which is good. So, the RUST program has a preference for substantially underserved trust areas, or SUDA. And this is memorialized in a 2008 Farm Bill, which amended the Rural Electricity Act to add the SUDA initiative as a component to this. Tribal trust lands fall within the scope of trust lands, and the SUDA initiative gives the Secretary of the USDA discretionary authority in connection with electric, water, wastewater, telecommunication, broadband utility programs. So it's within that discretion. And then under that authority, the Secretary may do some specific things. I'll make sure. Yeah. You can provide financing with very low interest rates that can be as low as 2%. They can do things like extend repayment terms, he or she. They can waive either individually or in combination certain restrictions, such as like matching fund requirements. They also can waive credit support requirements from any loan or grant program administered by RUS. They give designated projects highest funding priority too, so they can sort of pick favorites a bit. So it's a large discretionary authority by the Secretary. So I wanted to provide some definitions for what this specifically means. SUDA underserved trust area, the term underserved, is defined as an area or community lacking an adequate level or quality of service in an eligible program. And SUDA substantially underserved, that defined term, means a community in trust land with respect to which the administrator determines that there's a high need for the benefits of an eligible program. So that is based on a determination from the Secretary of that program or of USDA to perform those powers and use the SUDA concept to the benefit of your potential application. So now turning to the EPA Drinking Water Infrastructure Grant Tribal Set-Aside Program. That provides funds for drinking water infrastructure needs, assessments, and construction of facilities for water treatment, storage, and distribution. This program is administered in collaboration with IHS, which has used this funds to design and construct projects. I give some examples of use of funds here. The EPA administers the Clean Water Indian Set-Aside Program under the Clean Water Act. Funds are distributed directly to IHS regional offices, and the statutory tribal set-aside is equal to 0.5% of funds appropriated for the nationwide program. That gives you a sense for how small this program is compared to the national program, though Congress in recent years has increased the tribal set-aside annually. So that's a good trend. I did want to say, I think we talk about this later, but knowing your contacts within the IHS regional offices is critical for understanding whether there's a project window on the horizon where you could take advantage of this. And that's just one of the key relationships that you want to be aware of and cultivate. Program funds may be used for investments necessary for all public water systems to comply with any Safe Drinking Water Act requirement. Assistance that directly or primarily benefits disadvantaged community on a per household basis, and it also for programs for water testing. So they're all eligible uses of funds covered here. So now, sorry. I did want to have a note saying that in recent years, especially the last 2 years, the coffers are as full as they have ever been for EPA clean water programs. So there's lots of money available in investment and water infrastructure. So these programs want to help you. They want to find good projects where these sort of initiatives can be taken up and followed through. So just a couple more details on the set aside. They provide funding for planning, design, construction of wastewater treatment. EPA uses sanitation deficiency system priority lists, and those are prepared by IHS to identify wastewater projects for funding. So, you need to get on these lists. Tribes need to meet with their IHS office reps, and you want to make this person your friend, your colleague, a partner on projects. The IHS area office rep should be aware of your tribe's needs and your priorities. So when you respond with a project idea, they already know that, oh, this will fit nicely with this available funding source. So one example of a funding source pathway that's less traveled, but available to tribes, is administered by the U.S. Army Corps of Engineers. And that's the Department of Defense Water Resource Grant Tribal Partnership Program, kind of a mouthful. But this tribal partnership program was developed through a Water Resources Development Act of 2000. And that authorized the Secretary of the Army to carry out water-related planning activities or activities relating to the study, design, and construction of water resources development projects. And those projects that are substantially beneficial to tribes or are located primarily within Indian country. So we list here some authorized activities for projects: flood damage reduction, environmental restoration and protection, preservation of cultural natural resources, watershed assessments, planning activities, feasibility studies, and basically a catch-all, any other important project deemed appropriate by the parties involved. So I did want to share a couple further details on this. There's some downsides of this program that you'd want to be aware of. There's a 50% cost share requirement from the non-federal sponsors to the project, which would include a tribe. And non-federal sponsors are usually state, tribal, private entities that are not the federal government. So it's within that group, whoever's a stakeholder to the project, the expectation is you need to pony up 50%. Though, if you do have a collaboration with a state, you could enter into a non-federal sponsor agreement and have some cost allocation. But those are complicated. Those are not straightforward. These are usually multi-year negotiations to get these things in place. It really depends on the project. I had some experience working on sediment projects with this structure and with the Army Corps of Engineers, and they do not do things very quickly. So these should be thought of for options of really long-term restoration projects. I think would be the best way of using these resources. All right, turning to one of the other categories is the IHS sanitation grants. This is, as I said, this is a division of the U.S. Department of Health and Human Services. They provide sanitation grants, but also technical engineering, construction, management services. And this is for installation of sanitary facilities in Indian homes, communities, and lands, pretty broad. IHS is required to maintain an inventory of sanitation deficiencies for each tribe. So they have some baseline calculations to try to determine priorities. But they also have to estimate the amounts necessary to eliminate deficiencies. So this, as you can see, that this rep in your regional office would be someone you'd want to have the most accurate information. So if you have a priority need, that can be addressed. Facilities covered for these types of projects include both water supply and waste disposal facilities. This is a free of charge technical assistance that IHS provides. These are engineering services, prep of specifications, contracts, drawings, inspections, and these are furnished for a fee equal to about 2 to 5% of the project cost. These types of projects can be administered directly by IHS, but they also could be administered by a tribe under a contract with IHS. So depending on how advanced it is, how complex, that's something you'd want to talk with your rep about, depending on what the roles and responsibilities are between your tribe and IHS. These are limited to certain projects. These are limited to homes generally built or renovated with funds provided under BIA's Housing Indian Program, or HIP. Which is like a secondary safety net type program. And it's also generally limited to non-HIP homes that have been built or renovated within the past funding year or previous year, so recent construction homes. HIP-related projects generally are given priority for these grants. IHS funding is limited, and IHS utilizes discretion for allocating funds to projects that will yield the greatest benefit. So they do prioritize based on sort of utilitarian concepts of the greater good. How many total people will this serve, or how underserved are the beneficiaries to these projects? So for these reasons, they make good candidates to be combined with other funding sources, such as the Rust Water and Facility Program, private loans, bonds, tribal contributions, obviously depending on the scope and scale of each project, as these could vary a great deal. Some recent news here, in May of last year, IHS announced they allocated $700 million from the bipartisan infrastructure law to improve tribal water and sanitation systems. This has been called a once-in-a-generation investment in U.S. water infrastructure, and that is certainly carried through to programs eligible with the eye towards tribal support. So increased funding should be available under this program. And after this part of the presentation, I'll share a link to this so it's easy to click for everyone here. But just a general statement, the funding sources may still need to be combined. There's a greater opportunity for this option today, thanks to this $700 million allocation. So I'm going to pivot to another program, and we just talked about water infrastructure projects. There's this program that covers community and other emergency response type facilities. So I'm going to cover that right now. So this involves the BRIC program, Building Resilient Infrastructure in Communities. It's a good acronym, I think. And the Building Resilient Infrastructure Communities program makes federal funds available to federally recognized tribal governments for hazard mitigation activities, a specific defined term. And importantly, tribal governments can apply as direct applicants to FEMA for tribal set aside, or they can participate in the national competition for funding. So there's tribal monies allocated directly, or there's a national bucket that tribes can apply for, and you can apply for both. You can also apply as a sub-applicant to an eligible state or territory for a state allocation. So again, you have some options in terms of how you layer the application to increase your odds of success. So the BRIC gives some background to the BRIC program. It's a recent FEMA rebrand of its pre-disaster hazard mitigation program, and it replaces that program, which was called as I stated, pre-disaster mitigation program. It's set up to allow governmental entities to prepare for and develop infrastructure to support the community during disaster events. And John, I don't know if you have some examples of some projects where this has been used. I know we talked about in previous trainings, you'd have a community center that may double as a shelter for certain storm events, and certainly geography could have an influence on what type of hazards you may be susceptible to. Can you think of some examples to share?
Sure. Well, that's an example. And I guess what you're thinking about mostly are projects that will create resiliency and safety for folks if there's like a big storm or a big event that occurs. So I think what's good to think about is being strategic about this. What we're trying to do, and this we're trying to cover in these infrastructure areas, is how can you use these various programs to meet your needs while also meeting the criteria for the grant or program. In this area, I think it's, if you're making, let's say, you're building a community center or building something for your housing, maybe some infrastructure, but you're doing so in a way that does well during these kinds of hazard events. So you're building infrastructure, perhaps plus a community center. That would be a good example, because you're showing the basically FEMA that you'll use the money in a way that adds resiliency and adds protection during really bad events. But you're also meeting the tribe and tribal housing needs, because you just need that infrastructure, you need that community center, you need whatever it is. But you want to think, the key thing is, I think, thinking through that thing that you want or you need in a way that matches up to the grant, which is, it's building resilient infrastructure program. So it's you want to show you what you're building adds resilience. I think especially as Bill goes through the program and explains some more of the details, you'll see how that kind of fits in.
Thanks, John. And one thing you talked about is storm events. So that may mean something different if you're in the Pacific Northwest versus if you're in the Great Plains and Tornado Alley, and certain things where you'll have different infrastructure needs. So if you're concerned about the potential tidal wave, that would be a different type of facility than a tornado shelter, for example. So I did want to talk about some of the limitations here, and for considering this program. Generally, the BRIC program provides 75% funding to projects with 25% non-federal dollars, so there'd be a 25% cost share. And however, the economically disadvantaged rural communities, which are called small impoverished communities under the Stafford Act, are eligible for up to 90%. So that could be bumped depending if you meet certain criteria. And I could give the definition here. A small impoverished community is a community of 3,000 or fewer individuals that is economically disadvantaged, with residents having an average of per capita annual income not exceeding 80% of the national per capita income. So accordingly, lower income tribes with low to mid-sized populations may also be able to qualify for this 90% funding under the BRIC program. So a benefit for your baseline economic work you've done in your development plan to help figure out, am I eligible for this kicker of 15 additional percent? So the BRIC program sets forth certain priorities this past fiscal year. There's a link I'll share following this presentation that sort of explains what the certain priorities are. But these are likely to be updated, and they have been each year. So these are just from 2021, but there's some additional ones from 2022 that you should be aware of. And there's a real focus on mitigating risks to public infrastructure and disadvantaged communities, as referenced under Executive Order 14008. So that's in line with Biden administration's Justice 40 initiative and subsequent guidance that they've issued for how to incorporate that. And that order is intended to benefit disadvantaged communities, which include all geographic areas within tribal communities. They also focus on mitigating risk to one or more community lifelines and incorporating nature-based solutions, such as natural stormwater through the development of ponds or other surface water systems. The 2022 priorities also call for enhancing climate resilience and adaptation, as well as some other points of emphasis. So I'll share that so you can reference that following this topic presentation. So there is, I did mention, a tribal set aside 25 million each year, or at least that was the last 2 years. This may have gone up, but we'll have to double check. All tribes are able to apply for the tribal set aside, which can be used for capability and capacity building activities, as well as specific mitigation projects. And this includes the development of infrastructure and community buildings that are protective. So the concepts that John was saying where you have a multi-use facility that include part of this function and can address that. Major storm events. So wanted to give some examples of what is a mitigation project. And these are activities. Oh shoot, did I miss a slide? There we go, sorry. Capability and capacity building activities first. These are activities that enhance knowledge, skills, expertise of the current workforce to expand and improve administration mitigation assistance. You know, that we don't know exactly how popular these sort of activities are. They're kind of tough to do, but the purpose of them is to have tribes develop building codes, some partnerships, and to self-perform some of the mitigation planning and related activities associated with these sort of these projects. Some examples of mitigation projects I was speaking to include a wide variety of project types designed to do all of these three things. The projects must increase the resilience and public safety, reduce injuries and loss of life, and reduce damage and destruction to property, critical services, facilities, and infrastructure from natural hazards and the effects of climate change. So you need to be able to demonstrate that your product does all three of these things in your applications, which you'd have to demonstrate why it's necessary to address this existing need. So we want to explain that there's certain caps on the tribal set aside. The combined cost of any capability and capacity building under the set aside must not exceed $1 million, the federal cost share per applicant. Also, up to $500,000 of the tribal set aside may be used for mitigation planning and planning related activities per applicant. This planning and planning related activity funding is important because in order to maintain funding for specific activities, a plan must be created. So you can't really do any of this without a plan. And if more than one other thing to keep in mind, if more than 25 million is submitted in the sub applications under the tribal set aside, the capability and capacity building activities and the highest ranked mitigation project applications up to 25 million will be selected. So there's a preference regarding the type of projects they'd like to see funded under these auspices of this program. Once that cap is reached, all remaining mitigation project applications are going to roll into the larger national competition. So you're not totally out of luck if you don't get projects under the tribal set aside, but obviously that is the optimal outcome for an application, because otherwise you're fighting a much larger pool of candidates and projects. So I provided some examples of how FEMA utilizes certain technical evaluation criteria to score a project. And here's just sort of a breakdown of the potential points here. You note that infrastructure projects receive 20 points potentially. It's important to show how mitigation of one risk or to one or more community lifelines, which enable the continuous operation of critical government and business functions, you have to show that it's essential for human health and safety or economic security. So that's an underlying requirement for these and subject to this point scoring. So obviously a successful application has the highest score, so you can be rewarded with an award for these programs. It's important to demonstrate that the project incorporates nature-based solutions to risks such as flooding, to adopt recent building code for building code to score as well. It helps if the application was based on previous or non-financial direct technical assistance. And there's also additional funding for higher non-federal cost share, but that is only limited to a 5-point potential score there. It helps if the applicant has a status as economically disadvantaged rural community, as that is defined. And there's additional technical criteria. There's qualitative evaluation criteria with subject to point scoring. It evaluates such things as risk reduction and resiliency effectiveness which includes how the project will address inequities and provide support for those in need in the area. And that's obviously a huge amount of this criteria allocated to that. It looks at if the project will enhance climate adaptation and resilience responsive to the effects of climate change. Evaluates how the application describes how the project will successfully be implemented and how innovative technologies and techniques to facilitate implementation will be incorporated in that project. The grant criteria also looks at how the application demonstrates community-wide benefits, especially to those in disadvantaged communities, how they will benefit. And it looks at outreach activities, types of community gathering or planning processes, how it was leveraged, how the input was received from diverse stakeholders, how it was gathered, and how was that feedback used in the project conception and design. So to the extent you can memorialize that with a good plan, that this will inform success on these criteria. And finally, it looks at how the application incorporates certain partnerships that help ensure the project meets the community needs, including those of disadvantaged populations. So we talked about some examples with John. We did want to give an example in the Pacific Northwest. There's a Shoalwater Bay Indian Tribe vertical evacuation tower. And that was an example of a vertical construction to help escape tidal tsunami waves that could potentially disrupt critical infrastructure. And but these types of projects are going to be fairly unique and dependent on where you live and what your tribal needs are. So that's just one example of how the natural conditions and hazards in the Pacific Northwest would vary greatly from a tribe in the Midwest or other parts of the state or parts of the country. So there's some additional information that's available on FEMA's website, and you want to pay attention to the notice of funding opportunity announcements, that these are posted both on grants.gov and they're discussed in the HMA guidance. And that's it. So Mark, can you please provide people with an overview of your expertise regarding broadband?
Absolutely. All right.
Oh, John,
So,
you're on mute.
John, were you saying something?
I was thinking that maybe this is a good chance to have a break and then to come back, since we're about halfway through the afternoon session now, or just about. And Mark has there's a fair amount on broadband that Mark will be going over, because it's important to know, especially for me, to understand how broadband works and what it's about, and then 2, what the funding sources, and 3, kind of how to think about getting ready to get the funding sources. So why don't we take a break until the top of the hour, and then we'll finish up the afternoon. Thanks a lot, everybody.
Thanks.
We're going to finish up the infrastructure financing discussion with Mark discussing broadband. So Mark, if you could go ahead, that'd be great.
Yeah. Okay. You hear me okay?
Yes.
Okay. Great. So yeah, as John mentioned, this section will go over some broadband basics, as well as some of the recent program expansions in federal legislation. As John and I have both talked about, my previous role at the Public Service Commission here in Wisconsin, I've been a part of a number of different broadband expansion programs, both with state funding and with ARPA and CARES dollars during the pandemic. And I've reviewed hundreds and hundreds of grant applications for broadband projects. So it's kind of a little bit of my background on this topic. So I wanted to start with just basics to make sure everybody's kind of on the same level, on the same playing field here. So really, what is broadband? And broadband, the term broadband is used, I think, to both refer to the actual physical infrastructure as well as the high-speed access, which are 2 separate things, but both kind of under the envelope of broadband. The Federal Communications Commission, the FCC, their baseline standard right now for broadband is what's called 25.3, which means 25 megabits per second download and 3 megabits per second upload. And just as a basic reference, basic email requires about 1 megabit per second. Web browsing is about 5. Social media usually requires about 10. Standard SD streaming of video requires about 5. HD or 4K streamings 25 plus. And video conferencing like this, Zoom or Teams, is usually in the 5 to 10 megabits per second range. That kind of gives you a rough guide for what those speeds are. And those are basic minimums on the speed you need to even do them. Probably not optimal speeds would be much higher. And on any given line, the more people and devices that are connected, the more bandwidth you need for proper broadband coverage. So just some basics about the physical infrastructure and how broadband is delivered. They're kind of broken out into a number of technologies here. The first is fiber optic cable, or fiber, which is kind of the gold standard. Fiber optic cables contain thin strands of either glass or plastic that transmit data as light, reaching speeds into the gigabits per second, which is 1,000 megabits per second. So that's the gold standard. That's the fastest that can be found right now. The next is coaxial cable, which is one of the more common broadband media, using the same lines as a cable TV, plug into your wall. And that's in the range of the hundreds of megabits per second. Next down the line is digital subscriber lines, or DSL, which are generally copper phone lines that can transmit internet and data that way. Not all copper telephone lines are capable of transmitting data via DSL. And DSL is usually sufficient to get 25.3 speeds, but barely, and probably isn't the greatest media for that. But it is the easiest way to get internet into rural areas, which usually already have the phone lines installed, and that physical infrastructure is already there. Next is wireless internet, which can be either fixed or mobile. Fixed wireless involves wireless transition of data from an antenna tower to a permanent location, and then either can beam signals to a dish on a house or distribute it through physical lines from that tower. You can kind of think of a radio tower with lines going to each house, and the radio towers are kind of set out in set distances from each other. Fixed wireless is relatively quick to deploy and can get up to probably 50 megabytes per second, just to give you a general idea of what their speed is. And then mobile wireless is what is generally considered cellular phone data, but it could also be mobile hotspots, which are like little cards or little modems that you can take with you, similar to a cell phone. And mobile wireless is usually referred to in generations. It's 3G, 4G, 5G. So third generation, or 3G, is 1 megabit per second or less. And this is really what cell phones were on before smartphones. These are largely being phased out completely by cellular providers. And I think by next year, most of the major providers won't even have a 3G network anymore. 4G kind of came along with the ubiquity of cell phone and smartphones, and averages in the 10 to 20 megabits per second. And the latest technology is 5G, which, so I should go back. 4G probably isn't the greatest media to get broadband, whereas 5G is kind of thought of on a level similar to cable or to fiber optic as far as mobile wireless. 5G is being pretty rapidly deployed, but mostly only in urban centers at this point, and it can get into again, that gigabit or 1,000 megabits per second. And then finally, there's satellite internet. This is, I guess, the easiest to deploy, in a sense that there isn't any physical infrastructure that needs to be involved other than a satellite dish on a business or on a house. And that can get speeds up to about 100 megabits per second, but it's generally slower than that. And it's also very expensive to deploy right now. I mean, there's not a lot of physical infrastructure to install, but you still have to shoot a satellite up into space, and that is pretty expensive. Just looking at Elon Musk Starlink is one example of this technology that they're working on developing, but is still probably not the way to go at this point. So a couple terms related to construction of broadband that you might see in applications. So FTTH or FTTP stands for fiber to the home or fiber to the premises. This is the longest lasting and highest quality connection, and generally is fiber optic cable run underground directly to the end user as the home or business. It's also the most expensive. You're digging trenches, laying cable is going to be the most expensive way of delivering internet, but it is the most reliable by far. Fixed wireless or radio towers, again, these are faster to construct than fiber. They're a little less expensive, but they're also less reliable. Just as an aside, I would say from the programs in Wisconsin, the applications that we would see, 99.9% of all projects proposed were either fixed wireless or fiber to the home. There wasn't much other projects proposed, not that they couldn't be, but just to kind of give you a flavor for what those are. Some other terms that you may see are backbone, middle mile, and last mile. And this just refers to the section of the infrastructure in relation to that broader broadband grid. I kind of think of these as backbone as the interstate, middle mile as the state highway, state trunk system, and then the last mile is a surface street to your house. The last mile is generally the most expensive piece of infrastructure installation, but arguably the most important, right? Because you can have the most robust backbone system of broadband and high quality fiber optic cable, but if it runs right past a home or business and doesn't actually connect to that business, it's useless. So that last mile is really where the rubber meets the road. So as it relates to broadband funds, I just kind of wanted to frame the problem that's being solved here. So the last estimates I've seen are that about 7 million Americans don't have access to that high-speed broadband 25.3 standard, which includes I've seen anywhere from 21 to 30% of tribal lands don't have that broadband access, 17% of rural lands. The other problem is that although 96% of households in the country may have access to that high-speed internet, only a little under 70% actually subscribe to the service at that level. So there's this, with the administration of all these programs, there's this question of access versus affordability. And policymakers on the state and federal level have obviously decided that it's important to have broadband and provide as much access as possible, but the grant programs and the decisions on which projects get funded within any program are constantly juggling what's adequate access. What speed are we gonna find? What speed are we gonna install? And then what's actually affordable to the consumer, to the end customer, and to the funding entity. So the Infrastructure and Investment and Jobs Act, or the Bipartisan Infrastructure Law, the bill, was signed into law in November of 21, and among a number of other programs, it provided almost $65 billion for broadband across 7 major programs. Some of these programs aren't open for applications anymore, so I'm not going to touch on those. I'll just touch on the ones that are kind of being deployed right now. The largest one, this Broadband Equity Access and Deployment, or BEAD, B-E-A-D program, is the biggest and beginning its rollout pretty steadily now. The other 3 are the Affordable Connectivity Program, the Digital Equity Act, and then an expansion of private activity bonds. And you can see the numbers that are associated with each of these, and we'll go through them one by one. So as I said, the BEAD program provides about $42 billion for broadband planning, deployment, mapping, equity, and adoption. And this is a formula-based program where each state gets $100 million as a baseline, and then additional amounts depending on the number of unserved locations in the state. And it's kind of a ratio between how many locations are unserved or underserved in relation to how many of those locations exist throughout the United States. Each state is going to design its own program on how it distributes the money. And the bill specified that states have to coordinate with tribal governments when they're doing their planning. believe at this point, every single state has submitted an application and has a plan for deployment going forward. And again, yeah, the program doesn't require, but strongly suggests prioritizing unserved, which is no access to 25.3 speeds, underserved locations, which doesn't have access to 100 to 100 download, 20 upload megabits per second, and then community anchor institutions. And that's how they want states to dole out the grants when they actually administer their programs. So again, each state will decide how the money is going to be awarded to sub-grantees or sub-awardees to deploy that infrastructure. Each state has a broadband office, but the infrastructure each state has to implement their programs is going to be pretty different state to state. So just as, again, as one example, the Public Service Commission of Wisconsin has had a competitive broadband expansion grant program for about a decade. And these are running competitive grants every year, usually in the $15 million to $20 million range. But the current estimates right now are that the state's going to get $700 million to $1.2 billion in extra broadband funds. So that kind of gives you a flavor for the type of expansion we're talking about here, 100 times what they've done in the past. Because each state is different, there's not a whole lot published and out publicly right now on the programs. So I would just encourage everybody to, if you're interested in pursuing these grants and the money for infrastructure, to stay in touch with your broadband office. I'll put a link in the chat that has Broadband USA, the National Telecommunications Association. They have a link to every state and their broadband office and a contact person at each state. So I'd strongly encourage you to check that out. What we do know, though, is that there's certain criteria that every state has to include in their programs. There are a few exceptions, but each subgrantee who's awarded money in the grant program has to provide at least a 25% cost share or matching funds for the projects. And this portion of costs can be provided by a pretty wide range of entities, as can see here on the slide, utilities, cooperatives, nonprofits, for-profits, regional planning organizations, and those are in addition to the sub-grantee, who can be pretty much anybody. As a general rule, federal funds are not allowed as a cost share. However, there are some programs that were created in the American Rescue Plan and the CARES Act. That funding that's specifically set aside for broadband can be used as the match in specific situations. There's also an exception to that 25% cost share requirement for certain high cost areas, which are areas that are remote, have a low population density, unique topography, high rate of poverty, or other circumstances as defined by the Assistant Secretary of Commerce. And so I haven't seen any written information about what those standards are going to be yet. So again, we'll stay tuned as this develops. And the broadband, the BEAD program is being rolled out now for the next couple of months. So it'll be important to keep an eye on this in the near future here. So the next program is the Affordable Connectivity Program. And this is a $14 billion program administered by the FCC. And it provides a discount on internet service of up to $30 a month for eligible households and up to $75 a month per eligible household on tribal lands. And these funds actually go right to the broadband service provider directly. And this kind of gets at that issue we talked about before versus, access and affordability. If you have access to it, but you can't afford the service, that doesn't really help anybody either. So this is trying to get kind of at that problem. It also includes a one-time discount for up to $100 for a laptop, tablet, or desktop computer with a co-payment requirement as well, as you can see here on the slide. To be eligible for the ACP program, and in particular the enhanced tribal benefit, the household has to be located on qualifying tribal land and be below 200% of the federal poverty level, or meets one of the criteria. listed here in this slide. Member of the household has to be, either received a Pell Grant or eligible for existing internet programs through their internet service provider or ISP, participates in one of the following programs. Again, I won't list all these off. I think the slides will be available, but there's a pretty wide variety of programs to showcase eligibility for these programs. And then there are specific programs, assistance programs for qualifying tribal lands, such as Bureau of Indian Affairs General Assistance Program, Tribal TANF, food distribution programs, and Tribal Head Start. The next is the Digital Equity Act, which is a $2.75 billion program divided up amongst 3 sub-programs: the state planning grant, state capacity grant, and then a competitive grant as well. The planning grant supports the creation of digital equity plans for the states and then feeds into the capacity program, which funds the implementation of those plans and helps scale up digital literacy programs to provide people the skills necessary to actually use the internet. The state planning capacity grant deadlines have passed, so I'm not going to go into those in a whole lot of detail, but am encouraging everyone to keep an eye on those as the awards are announced, because tribal governments were eligible to apply for the planning grants, and I believe around 470 had submitted letters of intent to participate. So we'll see where those grant awards end up. But I think most important then is the competitive grant program as part of the Digital Equity Act, which has to begin within 30 days of the capacity grants being rewarded, which right now is expected, the latest I've seen is expecting this program to kick off sometime in mid-2024. But again, that could change. Unfortunately, you just kind of have to keep an eye on all these programs as they're being rolled out, as they're being created almost. The competitive grant program's a $1.25 billion program, again, aimed at digital inclusion activities to facilitate the adoption of broadband and training and equipment. But again, there's not a lot of details on this program right now. What we know, though, is that the tribal organizations are eligible for the competitive grant program, provided that they're also not already administering grants under one of the other capacity or planning grant portions of the program. And this program can provide a federal share up to 90%. And the last piece I'll go over here is the private activity bonds, or the expansion of private activity bonds. The bill allowed state and local governments to issue private activity bonds to finance qualified broadband projects for rural areas. And as we talked a little bit earlier, kind of in a different context, government bonds are generally issued to finance projects owned by state or local governments like offices, highways, et cetera. And a key advantage of these is that the interest is exempt from federal income taxes, which keeps the cost of the bond lower and saves the governmental entity money on the issuance and the overall sale. So these qualified activity bonds are again tax exempt to finance certain private projects that benefit private entities. And a qualified broadband project, which was added to a long list of other activities that are eligible, excuse me. And a qualified broadband project is one that provides service within a census block in which over 50% of the households don't have fixed terrestrial broadband, which you probably can think about as that fiber optic cable. And either residences, businesses, or a combination get access to speeds of at least 120 megabits per second through the deployment that the bond is financing, or that 90% of the residences and businesses with new access to that speed must have had less than 25.3 before the build out. This program also requires some notification to the internet service providers as part of the program. And that's broadband.
Great. Thanks, Mark. So we've now basically completed the discussion about infrastructure, the funding for infrastructure, except for the energy stuff, which we keep as a separate unit at the end. And so maybe tomorrow morning, we'll just kind of walk through again what we got and with the real highlights of where we came from and where we are when we start tomorrow. But I'll start the financing rental housing now, so we can at least, get a fair way into that. We'll probably be mostly talking about the general grants for that today, and then maybe tomorrow pick up with a summary of that and go on forward. So what we're going to be talking about here is, there's a fair amount of overlap on certain grants that are, truly multi-purpose, and therefore can cover housing as well as infrastructure. Those include the IHBG, competitive IHBG, and the ICDBG, all from HUD. And then we'll talk about the Federal Home Loan Bank, AHP program, which is the Affordable Housing Program, Supportive Housing and the Home Program. So kind of going forward here, when we're thinking about the grants that are available, these are the ones listed again, I guess. And, it's obviously very, very important to be closely connected with HUD, because they have a lot of the funding, the base funding basically, that's available to housing authorities. And to make sure that you're thinking about both the competitive IHBG and the ICBG in addition to your kind of your non-competitive funds. But another really important grant program, I think, is the Federal Home Loan Bank Affordable Housing Program. What it does is it basically provides another, at this point now smaller, because the HUD funds have really grown a lot, but another important grant program that's kind of like, IHBG, competitive, and ICDBG. So it gives you another kind of kick at the can to get the kind of money and the types of money you get from the HUD funds to really help bolster your programs for your housing. And then we want to talk about the home program as well. It's very limited use in any country, but can be used. And it's kind of it's one of the largest kind of home funding programs, or housing funding programs out there. So it's probably good to at least be aware of that, what you can do with it. But again, I think that as a general matter, you want to use your IHBG non-competitive money wisely. You want to, have it available for, especially leveraging other funds if you can, which sounds like some of the folks on this call have done that, which is great. But then you really want to be on top of both the IHBG competitive and the ICDBG. And then I think the fourth one you really want to be on top of is the Home Loan Bank program too, because combined, those can really provide a lot of funding per year for your development programs. This is similar to the slides we went through before, but now focused on housing. So the NAHASDA, Indian Housing Block Grant Program, is very flexible. We talked about, we had up on the slides before some stuff that was related to things like infrastructure, which is also somewhat noted here, but there's also just kind of just the full range of things that is available for. It includes the modernization of or operating assistance to housing previously developed under a contract between HUD and a tribal housing authority. So that picks up your operating expenses as well as rehabilitation of housing and stuff like that, and just modernization of your housing. It also picks up affordable housing development generally, including property acquisition, site improvement, and all the related stuff we talked about before, which gets into more infrastructure stuff. But it really, it's very, very flexible, because you all, I think, are aware. It's also, limited. That's the biggest thing. And so basically the problem has been, that the appropriations from Congress have generally been inadequate to address housing shortages. So that's where you have to really start to think, creatively about how do we get money if we're going to both rehab our existing housing to keep it up to date, and then expand our existing housing to grow the housing available to the members. And there's, I guess, every tribe I've been associated with has always had issues of not having enough housing to meet the demand on the reservation. So the question is here, how do we fund that? And that's what we'll be talking about, in these number of sections coming up. And basically, those funds are are from NAHASA are typically required to cover the administrative costs and costs of operating units. And don't leave a lot of extra money left over to build homes. But it sounds like, and we've experienced this too with other housing authority clients we worked with, or housing authorities we worked with, I guess you'd say, that a lot of them have been, even though it takes a lot of work, they've been good at identifying some of their funds that are available from the non-competitive NAHASA Black grant funds to create money, at least for leveraging of other grants to do stuff on the reservation for housing, to build homes, to rehab homes, and to put an infrastructure in place, things like that. So this is basically the slide we had before. So just to disclose that, but just because it's equally important here, or perhaps even more important, the IHB competitive program was put in place recently in 2018, the 2018-2019 Appropriation Acts, and it is really was originally meant to address the significant housing shortage in Indian country. So it used to have, I think it doesn't have as much anymore, but it originally had more bonus points for new housing as compared to other activities such as infrastructure and housing rehab. But the big news is, this bottom line is that there's a lot of money available here. It's $150 million. It's obviously just for tribes. It's just for tribal housing, basically, and it provides just a lot of money for these kinds of projects. And besides probably the low-income housing tax credits, which we'll talk about later on, it's probably the most money that can be available to a tribe or tribal housing authority to build new homes and to as well as to rehab homes. And we talked about this before, the different scoring factors, but it's a couple things to point out again, or in addition to what we talked about before, is that this also relates to, I think, the initial slides we had, which were related to building your development team. Another reason to build your development team and be aware of everybody on it and make sure they're all, kind of everything's up to snuff, kind of in terms of what you want to do for development, is that development team, a lot of the members on that are the same folks that you'll end up putting into your application and showing the capacity applicant, which is key for both the IHBG competitive and the ICDBG grants, where you need to be able to show these various folks were involved in recent relevant and successful projects, and kind of just to show that you have a good team together on your project. So actually what you need to put together to get your grants also helps you get the grants, kind of in a way, or that what you need to put together to identify your projects and decide what to pursue and actually pursue it also helps you with your grant applications and showing that you can do stuff. So we went through these things before. I guess the key things, again, to be aware of those is really thinking through what you're doing and why, to be able to explain the need and extent of the project, and to think about how you're going to build out your project to show the soundness of approach and your comprehensive and coordination for your project. So I think that it's another reason to also treat seriously kind of getting your development team together and following the steps when you do develop, so that you can, because a lot of the HUD applications, probably more so than the other ones, but a lot of the other ones have that too, this idea of really showing how and why you'll build the project successfully. So the more you interact among your team and have ideas shared in terms of how we're going to make a project work, the more likely you get the funds, that you can get the project going, and you can use that project, whatever you develop, to help you explain how you have recent and relevant experience, which I think for all the grants that we've been involved in and all the grant projects we've been involved in, that's really kind of the key thing, besides obviously having a decent project itself, but really showing why you have a team together that'll work and how your approach will work to your project. So all that stuff, it all kind of interplays together. And then again, we've talked a lot about climate change. Climate change has come up, and I think there's some questions about that when we first started going. That it's there because of the Obama administration's focus on that issue, which obviously was somewhat there under Obama, and then went away under President Trump, and then came back again. And now I think that it also makes sense for you to be thinking about all your projects in terms of two things that are related to climate change. One is resiliency, how your projects will be more resilient or be resilient in situations where there might be greater amount of storms, greater amount of heat, greater amount of just disruptions, natural disruptions to what's going on. It's also probably good to know for your projects too, to just be thinking ahead about how, if we build this, will it survive, perhaps be more likely to do well with, you know, more 100-year storms or more other significant storms, other significant events. So it's probably also just good planning to have that, but it also helps you score better, which on a grant like the competitive IHBG, which is so both valuable because it's up to $7.5 million in amount, and competitive because of that. If you can get those extra 2 points on the project, that could be the difference between getting and not getting the grant, you know, kind of thing. So being on top of those things also are really important. And then I guess the last thing is also for all these projects, especially this type of project, you know, thinking about how we're going to get the leveraged resources, because I think it's tempting to say, well, we don't need to get leveraging because you could get the grant potentially without it, but if you don't get the 5 points, you're probably not going to get the grant, and it's probably not going to go forward. So if you can work with the tribe on leveraging funds, use your NAHASDA funds, or also think about what other funds might be available, that'd be great. One thing actually to think about in that area is, in addition to what I just mentioned, you know, tribal funds, perhaps through, if they were right, perhaps through the right-of-way discussion we had, or NAHASDA funds or funds like that, is thinking about the funding that's available through your state, probably through either, it varies by state, I guess, and we'll talk about this later on in the energy area as well, but there is, you know, oftentimes significant funding that can be available for housing and other projects related to the energy efficiency measures put into the project. Some folks are real fortunate, like if you're in, like for example, actually no, I forget the name of the organization, but maybe stepping back for a second, there are, you know, every state and every utility can potentially be a source essentially of funding for energy efficiency improvements, both in new homes or new building and in rehabbing. So, and it varies a lot. You know, some states and some programs, some utility programs and some related programs provide most of the resources to rehabbing homes with the idea that, and rehabbing other buildings with the idea that those are the really energy inefficient ones, that it'd be helpful to get them up to speed. But some also have funding for sometimes more limited, but for new homes. So if you're using the IHBG for a new home, new homes being built, you still be able to get a fair amount of funding for a lot of the energy efficiency components in the project, either from your utility or from a state entity or state organization. Like Wisconsin, it's called Focus on Energy, but different states have different programs. In New York, it's called NYSERDA, and so on. But most states and most utilities have programs like that, which we'll talk about more in the energy section, but that can also be helpful in getting the funds. You might put up your NAHASDA funds as the initial source of leveraging, but then know that, well, hey, we can always you know, help fill that in through, let's say if you're Wisconsin, Focus on Energy money. And it makes sense then also to be in contact with those guys to get a sense of what you can potentially get, and stay in contact with them, because it makes sure that they're giving you, you know, they're helping you out, make sure you're getting all the resources you can back, so that you can hopefully, through programs like that, they'll really you know, meet the leveraging requirements to get the maximum points, but also minimize the amount of NAHASDA or other tribal or housing dollars you have to use up for your project. This is, I think we have the same slide before, but the key thing again is really this very significant amount of money available here, and therefore the competitiveness. And I think it's one of those that, you know, you may be discouraged because of the competitiveness of only 25 awards, but on the other hand, it's so valuable. It probably makes sense for you to at least start to think about it, and perhaps build a team to make sure, maybe you don't even apply this year for it, but you apply the following year, just to make sure you're thinking about it and going after it, especially if you have a desire to build new homes. It's you know, it's so hard to get money for that, and or if you want to rehab homes too, it's really important that you're aware of the amount of money available, and you're thinking about strategies to go after it, even though it's competitive. So then the next grant, which we've already gone through, so I'll kind of go through this kind of quickly, but I also think it's important. It's such an important grant. It's good to hit it twice. The ICDBG, you know, is more focused on non-housing stuff than the IHBG is, but it also is very important for housing rehab, and we've worked with housing authorities that have gone after that funding for, you know, after the ICDBG funding successfully for housing rehab. This is another example of where, you know, the leveraging can come in from a variety of sources on housing rehab. Most particularly, again, the state and the utility programs that are available for energy efficiency and related stuff like that, in large part because those programs may especially in the housing rehab context, may be able to easily cover the 25% cost share. Especially if they're, you know, some of the more generous programs, which a lot of states have. So I think this is another opportunity to, you know, again, I think the primary focus of this webinar is really what you can do beyond your NAHASDA money. So this will, again, can help free it up. It may even use the NAHASDA money again as an initial commitment if it's needed, but the ability to then go get in Wisconsin, focus on energy money, or in New York, NYSERDA money, or wherever you are, the relevant source of energy efficiency funding could really allow you to rehab homes and have most, if not all, the leveraging potentially covered by cost share, especially in states like for instance, one project we worked on was in New York, and with NYSERDA, they had very significant, and sometimes up to 100% funding for lower income homes. So if you can, you know, pick at least enough of the right homes that would fall into a category of getting a high percentage of state funding, then you can potentially meet all the leveraging requirements for a HUD ICDBG, and do really well under the program. We'll talk about the solar panels, and well, especially the solar panel, the reference to solar panels for ICDBG, which is actually referenced in the implementing regulations in the energy section some more. So this grant is truly, you know, multi-purpose. So you can use it for a wide variety of stuff, including for energy projects if you wanted to for your housing. And then it could also be used for land acquisition. So if you're kind of almost infrastructure on your projects, but you need to acquire land because you don't have actually enough tribal land to build the projects you need, you can use it for land acquisition as well. So it can be used for a wide variety of kind of A to Z, except for new housing, basically. That's what this slide's about. It can only be used for new housing as a last resort for the relocation of displaced persons or projects carried out by community-based development organizations. So really, in most instances, if you're looking at new housing, you're really looking at more competitive IHBG, and then also probably tax credits and perhaps HP potentially, but not so much ICDBG. And this slide, I guess, not our initial stuff, but you know, as I think is the case for all of these HUD grants, or both, I mean, say ICBG and competitive IHBG, as well as same thing comes up in the DOE grants and a lot of other grants that are focused on tribal organizations, you know, which include tribal housing authorities. You can apply for these grants provided that you're authorized by a tribal government resolution. So one thing to think about is this kind of timing, that you typically would need to go to the tribal council for approval on the ICDBG. I think, as I mentioned before, the ICDBG is actually, you know, incredibly valuable to a wide variety of tribal entities. It's the tribe itself, but as well as tribal entities and tribal departments, because of the fact that it is and covers so many different kinds of activities. So there's also the issue of just being in line with the tribe. If you can, it's great. Some tribes just make it available to their housing authority every year, which is probably the best for housing authorities, obviously. Some go back and forth, as I think I mentioned earlier this morning. And some, I think, just, it's more like you're in a competition for it. But anyway, it is such a valuable grant and such a multi-purpose grant that it makes sense to be thinking about it, and kind of always be thinking about what's the use for it in case you got to compete against other tribal entities for it. This is the same slide about the LMI, the low and moderate income stuff. The key thing for housing development is that if it's like in a single family, if it's single family homes, then each one of them has to be occupied by low to moderate income folks. And if it's a multi-family housing unit, for instance, let's say it's a four person unit or a larger apartment, then at least 51% of the units must be occupied by low and moderate income people or families. This just has the same slide about how the funding comes out, how it came out, I guess, for fiscal year 2021, becoming available in July of 2020, July 29th of 2022, and then the application deadline being in October, and then funding being made available. And it's now become a very significant amount of money too. So the bottom line is the ICDBG and the competitive IHBG are two that just really need to be on everybody's radar and going after, I believe. And then on the this just shows again the amounts per office, ONAP area office, and you're competing against your own region, or your own office. So it's important to just kind of know that. And then the amounts have gone up significantly, up to $2 million, and then beyond for larger tribes now. These are the rating factors again, which we went over before. So maybe I'll just kind of go on from there. And the same kind of considerations I think apply for this as competitive IHBG and being ready to be on top of those things. And then thinking about climate change, thinking about sustainability for your projects, which would include, I think, both highly energy efficient equipment in the homes, potentially could include things like solar on the roofs, and would include, I think, resilient features, so that the homes are able to withstand large storms, things like that. So to be on top of all that stuff is really important, and also being aware, I think, of the need for stuff in light of the climate conditions that are going on. So I think we now have an administration that we seem to go back and forth between one that is very focused on these kind of sustainability and resiliency issues, and then one that is not, and then one that comes back again. So especially on the kind of on the carbon reduction side or the sustainable side, as opposed to perhaps the resiliency side, that's where it really shifts back and forth based on administration. But I think we're in this kind of administration now, so you want to be thinking about that. I think it definitely makes sense, I think, in terms of both cost savings and resiliency to build resilient buildings and to make sure that they have energy efficiency components. But we now have an administration that's more focused on those things too. So those are the two. And I think it's a little bit repetitive because they cover so many kinds of things. But if you're really thinking about two grants to really go after, those are the two key grants to make sure you're in good stead for and in line for. This is a third important grant though too. Now the Federal Home Loan Bank Affordable Housing Program, called AHP usually, which is a subsidiary, subsidy, I'm sorry, or essentially a grant that's provided. But I'll talk to you about how it works now. The way it works overall is that there's 11 regional federal home loan banks throughout the country, and each is responsible for a territory, which I'll go through in a second how that works with the map that I have. It's the next slide. Those were created by the Federal Home Loan Bank Act as a government-sponsored enterprise to support mortgage lending and community investment. So they're both there's a Federal Home Loan Bank for each region, and then there's charter member-owned banks, and then but it's under an act that's a little bit more focused on home lending, and then especially community investment. So so these banks are required to have, funds that can become available for the regional banks have funds that are available for potentially grants or subsidies for low income housing. So that's why it exists, and that's why, or its background, and because of that, it's important to be aware of. So here's the 11 districts. You can see there's different regional offices. For example, there's the Des Moines office in this huge region. The reason why there's a huge region there is that it used to be also a Seattle office, and it used to, cut off for the west side of that region. But there's, again, there's a bunch of regions basically that have, each one has a number of states within it, and then each region runs its own, AHP program basically. So I'll be talking about the basics of this. The basics don't drill down into the real specific details, in large part because there's 11 different sets of really specific details. But the basic idea of each program is to provide funding, not to just like the HUD funding for competitive IHBG and ICDBG to help fund housing improvements, basically, for lower income folks. So the HP program provides what they call subsidies, which are really basically is grants for both home rental situations and home ownership situations. So we'll focus more on the rental now, because we're talking about, funding rental housing. When we get to the ownership, we'll talk about AHP again, I think, in that context. And so each regional bank is required to create and publish and put forth its own AHP implementation plan. They put it forth on their website, and it describes the program requirements for its own AHP subsidy program. And those standards or requirements relate to things like income standards, the application program requirements. There's a certain amount of money that's typically set aside for home ownership programs. And they also have, in some cases, revolving loan funds and loan pools, if they provide those as well. And then monitoring requirements, in large part to make sure that the homes stay available to lower income folks for a substantial period of time. I think it's 15 years. And then they have retention agreement requirements. So the requirements basically out there, they set forth what you have to do when you actually get the funds, and how you have to meet the requirements for getting the funds over time, or that you have to continue to meet, just like any other grant program, frankly. So the amount of the subsidies or grants, it varies per region, and I think it's been somewhat increasing over the years. Now they're basically between about $500,000 and $1.5 million per project, and it varies again based on what region you're in. So, and that can be used for the purchase, construction, and or rehabilitation of rental housing. So it has, you can, whatever kind of project you want to pursue in terms of housing, whether it's rental housing, whether it's purchase existing houses and they use those to construct new houses, or rehab rental housing, it likely should be that the various AHP programs in the various regions provide that availability. And then, they do focus on, low income housing, and actually lower than, essentially lower than the requirements for HUD homes. HUD is for the NAHASDA and the ICDBG, that's typically 80% of area median income. We're talking about at least 60% of the rental units being occupied by and affordable for very low income folks, which is they define as 50%, not more than 50% of AMI. So you're gonna want to be thinking about that a little bit. That can provide restrictions. This is, I think, a lot of folks that have been in housing a long time or for a while are very aware of this, of trying to make everything work out where you're having, in some cases, there's a lot of demand also that housing authorities are trying to at least help out at least a little bit on the for homes that are above 80%, but then even for the homes below 80%, you might have some that are just closing in just very close to 80%, and you might have some that are substantially lower. So you have to think this through. How do we make it all work in light of that? The same thing applies for the low-income housing tax credits, where they have restrictions on income that are in some ways more strict than for HUD houses. So thinking that through is very important, and kind of having a strategy for how you can get as much funding as you can, but still make it workable in light of what your demand. Who are the folks that demand your housing? What's the folks that would like to rent the housing from the housing authority? How to make that all work out is very important. Like a lot of other programs, the rents also can't in this program exceed 30% of the adjusted household income. So that's the idea here, is that you're not building, obviously market-based housing, just like HUD housing. You're not building that. You're not building in that context either. Or for the low-income housing tax credit housing, same idea. So they want to require that. They do require that the rents can't exceed 30% of the adjusted household income either. So when you think about the entities that are involved in an AHP application, there's essentially three key kind of actors it's important to think about. So there's the regional Federal Home Loan Bank, which is the equivalent of the HUD or perhaps the HUD ONAP region, in a way that receives the applications, scores them, and then makes the awards. So there's these regional banks, for instance, the Des Moines Bank, as I mentioned before, is one. Most of the other ones are kind of bigger cities, like Chicago and so on, San Francisco, for the Western region there. But that's the one that is acting more like the government granting agency, and is receiving the applications that, actually, while they put forth their own AHP guidelines, which tell you how to submit an application and how the process works, then they receive the applications and they score them and make the awards. Then the second kind of important player here is the member bank. So it's important for you to, if you're doing banking with whatever bank you are right now, and you're thinking about AHP, one key issue is whether they're a bank that's a member bank in the Federal Home Loan Bank system. If they are, that's a natural to be a member bank that you might work with, especially if you have a good relationship with folks and things are working well with them. If not, it's probably important you to find out, who are the member banks that you could potentially partner with on one of these projects, and you get connected with them. And then, because the member bank is actually the one that makes the application to the regional Federal Home Loan Bank, and it has to be a member bank that's in that region. So again, you'd be partnering with the member bank to put together an application that would go to the regional bank. And then the third entity is the project sponsor, which would be the entity that has an ownership interest in the project, and it's involved in the development management and management for the rental project, or provides financing to individuals for the home ownership program. So in this case, we're talking about the rental projects. So those would be owned by the sponsor once they're built, and the sponsor is the one involved in the development management project. So that essentially most likely is either it is probably the housing authority in our cases, where you're the project sponsor. You're the one that will own either owns, if they're existing units, they're being rehabbed, or will own if they're new units, and would be involved in the development and management of the project. And then you would partner as the sponsor with the member bank for them to help put together the application, and the member bank submits this to the regional bank, which then scores it and would decide if you get an award or not. So for tribes, typically the tribe or TDHE acts as a sponsor for tribal projects for, tribal or tribal housing authority projects. So, and again, as I mentioned before, you need to identify a bank that's a member of the Federal Home Loan Bank system, and you'd work with the bank on the preparation of the application. And then oftentimes, let's say if you're at a TDHE or at a tribe that does this, you'd be acting as a sponsor, your organization would be, and then you or potentially your consultant would basically help put together the application, because it's an application where the applicant's the bank, the local bank or the member bank, but really you're the recipient, you're the one that really wants it to flow through the most. So you'll be the one that put together the materials, and you're the one with all the information about your housing, generally in your housing project in particular. So, but a lot of folks use consultants to help put this together too, because there's folks that just do this kind of thing in their jobs, and so they get real good at it. So a lot of housing authorities have done that too with a consultant that puts it together. And then the websites of not surprising, the websites of the regional banks list their member banks. You can again figure out who might make sense to partner with. It probably makes sense to partner with somebody, a bank and have some relationship with that you can that you feel is good to work with and stuff like that. But a good way to check out who's available is to check out the Federal Home Bank's website for their membership list. And then most of these regional Federal Home Loan Banks have 2 rounds of applications per year. So it's something to be on top of. Again, I think if you're, I think all of you folks that are here are typically they're thinking about, well, how do we get funding for stuff? This is another important mechanism. So in addition to the HUD funds we talked about, it's important to know about AHP as well as the other programs too, but those get more and more specialized. So although I guess the thing I'd say about that too is that those other programs, a lot of them have a lot more money right now because of both the Infrastructure Act, basically the Infrastructure Act, as well as, I guess, secondly, just more funds being available through. Seems like the last few years they've been putting more and more money into these kinds of programs, which is great. So it's important to be thinking about all resources now because of just the more money out there. And then also, it's been mentioned by folks attending here, the inflation going on, which hopefully is now subsiding somewhat, but there's still increased costs for building going on. So with the HP program, it is highly competitive. It's a competitive grant program. But these are the kind of the key things you need to show in your application. One is the showing of need. I think both in terms of need for the money to make the project work, and then obviously you need to show that your folks you're serving fit into the need category based on income. They also want to know sources and use of the funds, which is not, you're probably not, if you've done HUD grant applications or other grant applications, that's obviously typical. They want to know, what other funding you have available for your project, and how the project is going to work out for you if the grant or subsidy comes through. They want both development and operating budgets. I think they're looking to make sure that the project makes sense, not only that you can afford to build it, but you can afford to operate it under your plan scenarios. And they also want to have a feasibility / market study to know that there is folks that will be able to move in the units, that if they're new units or the rehab, there'll be folks will be available to be in those units that meet the income guidelines, so that they're not building a white elephant, basically something that doesn't really have a market that it could serve. And they also want to know the sponsor experience. That's not probably too dissimilar to the requirements in the HUD grants for the administrative experience of doing projects, and if projects work out, that kind of recent, relevant, and successful experience idea from HUD, I think, is here as well. And then one thing that helps out tribes on these kinds of projects actually is the donation of land for less than fair market value, since obviously in a lot of cases tribes can provide the land available for the project because of the reservation lands they have. So tribes or through the Tribal Housing Authority can provide that. potentially free of charge, which can help the project do better from a scoring perspective. Sponsorship by a tribe is also a positive and typically in the scoring, so that's great as well. And then the idea of reserving at least 60% of the units for families with incomes not exceeding 50% of AMI is also a key scoring criteria. So those are three things that, especially the first two, and in a lot of cases, the third, those sometimes that gets to be more difficult if, you know, if your members make somewhat better incomes. But those three things can potentially be favorable to tribal applications compared to others, because the key thing here is, again, this is not a HUD tribal only program. This is a general program. So you want to be positioned well against, I guess, other tribes in the area, but also really anybody else too. And those are things that help tribes oftentimes. I apologize. We're actually at the end of the schedule. Let me just see once. Yeah, so let me just do this one slide real quickly. We'll pick up with the home program and kind of go from there. We'll also kind of hit the highlights from what we've covered so far that everybody's got an opportunity for any questions. But so we're just kind of really on the same page going forward. But the HP program or the grantee, you know, as mentioned before, you have to keep the project affordable as affordable housing for 15 years. Otherwise, you got to repay the subsidy amount, because you basically violate, make you sign an agreement, you basically violate it, been a breach, you have to pay back. So they're really on top of you. Same thing happens with a lot of their programs, including the low-income housing tax credit program we'll probably talk about tomorrow too. But with that, I want to thank everybody for being here today. We start again tomorrow at the same time. And please come with any questions. We can address any that remain in the chat too tomorrow morning. But thanks, everybody. Have a good evening. Bye-bye.
Thank you very much,
you.
everybody.
Cheers.